competition organized by Marathwada Legal and General Education Societies, Manikchand Pahade Law College, Chhatrapati Sambhajinagar. I request our honorable judges to please come on stage and take the dais. We will start our round soon. Please, your lordships.
Your Lordship. Your Lordship, the Council seeks permission to move on with the facts, and the Council would like to brief the facts in a very brief manner. Your Lordship, this particular facts of the case boils down to one critical aspect, that is one nation, one election policy, the simultaneous electoral policy, is constitutional or not. Before we directly get into the actual facts, let's get the settings clear. Your Lordship, the country that we are dealing here is Union of Karnataka, and it is paramount to Union of India, which simply means that there will be similar laws and constitutional provision that will be applying.
What you are saying about Union of India?
Your Lordship, it is as the facts of the case stated that it is paramount to Union of India. So on that basis, I am getting this. Your Lordship, yes, Your Lordship. Your Lordship, the facts begins from the Union of Karnataka, where ever since the inception of the democratic government formation, the Lok Sabha election as well as the state legislative elections were conducted simultaneously together. But due to various State Reorganization Act that was taken place in the Union of Karnataka, an emergency provision that has also invoked, and other premature dissolution of various state legislative assemblies has led to inconsistent in electoral cycle between the parliamentary election as well as the state legislative election, Your Lordship. Which simply means that the Lok Sabha will have election at a different point in time, whereas the state legislature of the different states will have election at a different point in time, Your Lordship. This has been criticized, this system has been criticized, stating that this plays a huge hindrance in the governance of the particular governance of the each government, which has formed the government in a democratic manner. And the critics have argued that this constantly infringes on the ability of the particular government to implement the long-term plans, Your Lordship. So that has led to the proposal of one nation, one election by the ruling government of the Union of Karnataka, which led to the formation of high-level committee which examined the possibility and plausibility of implementing simultaneous election at this point in time. So as per the High Committee report, there are certain constitutional amendments that has been put forth, and based on this High Committee report, the Constitution 129th Amendment Bill was passed in the Parliament and has received the assent of the President by October 15, 2024. The amendment sought to alter the key provisions such as including Article 83, 172, 356 of the Constitution of Karnataka. This has sparked a huge debate in the Union of Karnataka. The opposition party, NGOs and civil society members led by People for Constitutional Ethos organization has filed a petition.
You must be, I think that you must be aware of the real meaning of the word union.
Certainly, Your Lordship.
You said Union of Karnataka.
Karnataka.
Is it Union of Karnataka?
Your Lordship, let me clarify. This Union of Karnataka. So that is the country that we are dealing here as per the Moot proportion, Your Lordship.
Is it Karnataka? What is the name of that particular, this? Karna?
Your Lordship, it's Karnataka.
Ah, that is a.
Your Lordship.
Pronounce it as Karnataka.
Sorry, Lordship. Council seeks ignorance on that particular part.
Just.
So Council will correct.
When you are present in the case, you must be knowing here you are challenging a law, and virtually it is an amendment. Amendment brought by the Parliament of
Karnataka. Union of.
Just. Yes.
Your Lordship. And further to that, additionally, the state of Sinchal Pradesh also have challenged this particular amendment under.
So you are pronouncing this as a Chrontica as Karnataka?
It's Karnataka.
We do not know. Anyway, whatever that be, you meant that. Yes, please go.
Sorry, Your Lordship. The Council will further
proceed. No, we were taken aback and we thought that you are referring to state of Karnataka. That is why.
Sorry, Lordship.
Please proceed.
Additionally, the state of Sinchal Pradesh, which has also challenged this amendment under Article 131, and the Supreme Court has clubbed the petition of said to determine whether the one nation, one election is constitutionally valid or not. Your Lordship, if there is no any preliminary inquiry regarding the facts of the case, Council seeks permission to explain the annexure that has been added as the facts of the case, along with the facts of the case, Your Lordship. This is basically the 129th Amendment Bill that has been passed by the Parliament, Your Lordship. So basically, I'll explain this particular.
Where is your annexure? Where is the annexure?
The annexure here. Shall we?
Advocacy is an art. So therefore, first of all, you will have to bring to the notice of the court, which are the, if you are annexed a document, you must say that this is annexed and where the court will get that. And otherwise, where is the question of the court going through that document?
Your Lordship,
That is the way in which.
certainly, Your Lordship. But this part is a part of facts itself, Your Lordship. And it should have been supplied earlier.
Please proceed.
Yes, Lordship. So basically, I will explain the constitutional amendment that has been put forth through this particular amendment bill, Your Lordship. So basically, for example, let's say the Union of Karnataka has formed its government on 2020, and the term of the government will last until 2025, Your Lordship. So Sinchal Pradesh is one of the state in Union of Karnataka, where the government will be formed by 2020, and the
This annexure, you have not handed it over to brother. Only one copy is there.
It should be supplied.
Basic thing is that when somebody is addressing a division bench, you know that both the judges should have an opportunity to go through the documents.
Certainly, Your Lordship. Your Lordship, this is a part of the facts. It should be supplied by the...
Maybe it appears to be a very simple thing, but you must be knowing, because that is why we are giving some importance to these things. You must be knowing about it.
These copies were my personal copies, Your Lordship. The facts, since it's already been supplied, along with that, the annexure should have been supplied, Your Lordship. So the...
If you want to make any reference with reference, to this.
This is a part of the facts. No, Your Lordship, I have this another copy of that. Thank you.
Please proceed.
Yes, Your Lordship. The amendment as per section 129th amendment very clearly, I'll brief it in a very simple manner, Your Lordship. So let's assume that the parliament has formed by 2020. It will have its term till 2025, Your Lordship. Whereas in the state of Sinchal Pradesh, which is one of the state in Union of Karnataka, so the Sinchal Pradesh, let's say the Legislative Assembly also have formed by 2020 and shall last till 2025. But as per this amendment, if say the particular Sinchal Pradesh state legislature has prematurely dissolved at 2022, then it shall there will be a new election that will be conducted, and that government, the newly formed government, will have its tenure for 5 years guaranteed by the constitution till 2027. So in order to make this particular concept of the simultaneous election foolproof, what they have did is that they have curbed the newly formed government to only last till the dissolution of the parliament, which means only 3 years the newly formed government will have its power. So this is again a violation of articles which guarantees 5 years term to state legislature, Your Lordship. And this has been a part of the amendment that has put forth by the Parliament of Karnataka, Your Lordship. If Your Lordship is satisfied and there is no preliminary inquiry regarding the facts of the case, Council seeks permission to move on to the statement of issues, Your Lordship. Your Lordship, the first issue is whether the petition is maintainable, and the second issue will be focusing on the constitutional validity of one nation, one election, and the third issue will be focusing on whether one nation, one election infringes on the independence of state legislature by enforcing uniform electoral cycle, and finally we will be focusing on whether the people's rights are restricted to have an accountable government and by minimizing the frequency of election, Your Lordship. Your Lordship, the first...
Don't think that we are always interfering with you. And one thing you must be understanding, when you are presenting a case like this, you will have to say which is the article, what was the original position,
certainly,
and how the amendment was brought. And amendment was brought into which article, and what is the change, and why you are challenging that. And then, of course, the amending power, which is the source, and why you are challenging it.
Certainly, Your Lordship.
What is the unconstitutionality? This is the way in which you will have to address, especially when you are challenging the constitutionality of an amendment brought in by the parliament.
Certainly, Your Lordship.
Please. You got no case that the parliament is not having a power to amend the constitution.
It does certainly have the powers to have.
So the question is, what was the article? What was it originally? And what is the amendment? How it is unconstitutional? That is the way in which you will have to address.
Your Lordship, now at the very preliminary stage, I am merely briefing the facts of the case and annexure which has been attached to the facts of the case. Your Lordship, Your Lordship, at the very preliminary stage of this particular moot, I'm merely addressing the facts of the case and the annexure that has been a part of facts of the case, which is added by the moot society itself. So now I'll further deal with the issues, and on that particular issues and arguments advanced.
Your challenge is against the amendment to section Article 83.
83 also like 172 also, Your Lordship, which gives the duration of state legislature as 5 years term, which is guaranteed by the Constitution, Your Lordship. Your Lordship, first I'll deal with the maintainability issue. Then further I'll deal with the constitutional challenges and further on, Your Lordship. Your Lordship, first issue is whether this petition is maintainable under Article 131. Your Lordship, 131 deals with any matter that is pertaining between the Government of India and one or more states, Government of India and any states or states on one side, on the more states on the other side, or between two states, Your Lordship. All this matter or conflicts or any cases that pertains to this conflict between the government should be related to the question of law or fact that has an effect on existing legal right or extension of legal right, Your Lordship. Now the further argument, the council will explain how the state legal rights, which is the constitutional right, is also being curbed by this particular amendment, Your Lordship. So the state autonomy over the recommendation pertaining towards the appointment of Chief Election Commissioner of State Election Commission.
Are you have filed it, it appears that under Article 32 as also 131.
131 read with 32, Your Lordship.
How it will lie under 32?
Your Lordship, there is a huge violation of basic texture doctrine principle in this particular case, though the public interest litigation which was taken up by the people for constitutional ethos have been submitted in the court, Your Lordship.
What is the violation of the fundamental right to maintain this under Article 32?
Your Lordship, the basic texture doctrine of federalism principle is under question and being threatened by the 129th Constitutional Amendment Bill, Your Lordship. Let me explain with the further submission in the further issues, Your Lordship, because the second issue is focusing on the constitutional validity of one nation, one election. But the first issue will be focusing on the maintainability of the petition. So one by one, the council will deal the arguments. So let me sum up my argument for the 131 essentials, Your Lordship. As the state have the exclusive power over recommending Chief Election Commissioner for the State Election Commission. Your Lordship, when the one nation, one election has to be implemented, what happens is that the Election Commission will conduct Election Commission of India will conduct elections for the Parliament along with the state legislature and along with the third tier of government, which is the Panchayat and the municipalities, Your Lordship. But on those aspects, the only state legislative state Election Commission have the power to conduct elections for this Panchayat as well as municipalities, Your Lordship. If the Election Commission of India is going to intervene or encroach upon the domains of the State Election Commission, which is also a constitutional body under Constitution of India under Article 243K and 243Z, Your Lordship, where it is a separate constitutional institution that has been formed and gained its power through constitution. It has not gained its power through Election Commission of India or Union of Carnatic, Your Lordship. So in this case, there is a huge encroachment that has taken place. It's a face value of it, Your Lordship. The further explanation will be done on the second issue, Your Lordship. Next, we'll focus on the aspect of basic texture doctrine. The first limb of the argument will be focusing on amendment that has been made to the term of the state legislature, Your Lordship. As per the pertaining to anything related to state's interest, the 5 years term that has been guaranteed to the state cannot be violated under such a circumstances where they bypass the Article 368 Clause 2, which is that any matter or any amendment that can be put forth by the Parliament should have, if that is going to have a great effect on the state's interest, then it has to be ratified by half of the states in the country. But in this particular facts of the case, at no point in time it has ever stated that this particular bill has been ratified by any states. Rather, it merely got the majority from both the houses of the Parliament and went on to be and has been received assent from the President of Carnatic, Your Lordship. If the maintainability argument is satisfied, the council seeks permission to move on with the second issue, where we'll be challenging the constitutional validity of one nation, one election, Your Lordship. Your Lordship, a constitutional amendment can be challenged on 2 grounds.
Are you relying on any decision to buttress your contention that it is maintainable?
Certainly, Your Lordship. In the case of state of Chhattisgarh...
State of Karnataka?
No, sir.
Then?
State of... Your Lordship, in the case of state of Chhattisgarh versus state of Bihar, where the court held that even if there is a constitutional aspect which has been under question when it comes to amendment, the court can entertain petition under Article 131, Your Lordship.
Okay. See how many times we have interfered with him. So we will have to give some time to him. We grabbed his precious time, so we will have to give him time. Please proceed.
The council is grateful for that particular. Much obliged, Lordship. Council seeks to move on to the second issue, whether the one nation, one election is.
We will not put any question. You can continue for 2 minutes.
Your Lordship, the council is only dealing with the second issue at this particular point of time. There are two more issues that has to be further dealt, Your Lordship. Your Lordship, the second issue is based on whether the particular one nation, one election amendment bill is constitutional. It is humbly submitted that it is not constitutional. The reason why is that a particular constitutional amendment can be challenged on two grounds, Your Lordship. One is substantive and another is procedural. The substantive grounds is basically focusing on the basic structure doctrine from the Keshavananda Bharati to the recent judgment of Madras Bar Association with the Union of India from 1973 to 2015. The Supreme Court has clearly held that the Parliament has the power to make amendments to the Constitution, but that can at no point in time can violate the basic structure doctrine. And here it is submitted that Article 245 and 246 clearly enumerates the relationship between the state and center, Your Lordship. And 7th schedule clearly enumerates what are the subjects that the state will make laws on, what are the subjects the central will make laws on. But whereas the aspect of Panchayat as well as the municipalities fall exclusively within the ambit of state list under entry 5 of the state list, Your Lordship, and in 7th schedule. By making the amendment, they are encroaching upon the aspect where the state legislature has the power to recommend the chief election commissioner. So basically the chief election commissioner of the state election commission will be appointed by the governor, but that has to be based on the recommendation given by the state legislature, which is the chief minister and the council of ministers. With given such a rights from the constitution itself to the states, the Union of Karnataka, through this amendment, has encroached upon the rights of the states on this particular aspect and has encroached, totally dismantled the state election commission in this point, Your Lordship.
Any other point you want to?
Your Lordship, further let me...
You said you got 3 points.
Yes, Your Lordship.
You have covered now 2. What is the last one?
Your last one is the challenging the particular constitutional amendment based on the procedural grounds. So, Your Lordship, this particular law has serious effects on the state's interest. So it must have been ratified by the half of the states in the entire country. But it was not ratified by any states in any part of the country, and solely from the special majority that they have received from the parliament, they have went on to gain the assent from the president, Your Lordship. In that sense, the entire amendment is procedurally unconstitutional and shall be held unconstitutional by the
Which is that article? 368
clause 2, Your Lordship. Your Lordship, finally, I'll make the arguments regarding the last issue, if Your Lordship may permit. It's the 32nd argument, Your Lordship. Your Lordship, this particular way of implementing one nation election is...
No, please, I'll let your colleague argue.
No, Your Lordship, there is only one speaker from this...
Then, last point, please.
Yes, Your Lordship, when the one nation, one election policy is being implemented, it is solely based on the economical benefit that the government is going to gain. So basically reducing the number of elections would save a lot of money, and all of this aspect are being argued. But it is humbly submitted before the Honorable Court that this court shall only entertain the arguments based on the constitutional validity of the particular amendment and shall not entertain any aspect that is regarding the same, regarding the constitutional economical benefit. Your Lordship may grant me the permission, let me move on with the prayer, Your Lordship. Much obliged. Where in the lights of the issues raised, argument advanced and authorities cited, it is humbly requested that the Honorable Court may please to adjudge and declare that the petition is maintainable under Article 131 and read with 32 of the Constitution.
Yes, that's all. Prayers, of course, we will go with.
It was indeed a great honor arguing before the Honorable Bench, Your Lordship. Thank you so much.
If
Yes,
the
now,
Honorable
MP12R for the please.
if the Honorable Bench may confirm whether the Council is perfectly audible or not. Obliged, Your Lordship. Your Lordship, this is Council on the behalf of the Respondent, and I'll be dealing with all the 4 issues of the present case, and I'll be taking 15 minutes of this Honorable Court's time. Your Lordship, the first issue before us is that whether the present petitions are maintainable in the present case or not. Your Lordship, it is humbly submitted before this Honorable Court that the present petition under Article 32 is clearly not maintainable in the present case. If Your Lordship may refer to the case of Kochuni, given in flag 1, page 3 of the compendium.
You must have heard the argument of the council. He was insisting and he actually argued only that it is maintainable under Article 131.
Your Lordship,
We put a pointed question to him how it can be maintained under Article 32 when there is no infringement of fundamental rights. That question we pointedly put to him.
Indeed, Your Lordship.
The answer, he said that virtually it is maintainable under Article 131. So you may first address on that. Why it should not be maintained under Article 131?
Indeed, Your Lordship, but the present facts of the case says that there are two petitioners. First one, the NGO social activist and the advocate who have filed the petition under Article 32, whereas another petitioner is the state of Central Pradesh, which has filed a petition under Article 131 of the Crontican Constitution. Thus, in this light of the argument, Your Lordship, the Council firstly deals with the maintainability of Article 32. Your Lordship, if Your Lordship may refer to flag 1, page 3 of the compendium, in the case of Kochuni, the Supreme Court noted that for the right to move this code by appropriate proceeding, for the enforcement of the rights conferred by Part 3 of the Constitution is itself a guaranteed right. Your Lordship, in the case of Gopal Das versus Union of India, the Apex Code had held that Article 32 provides a mechanism for enforcement of fundamental right, and it is well established principle that a petition under Article 32 can only be filed when fundamental right guaranteed by the Constitution has been violated. Your Lordship, the petitioner has clearly failed to establish that which kind of fundamental rights guaranteed by Part 3 of the Constitution has been violated. Your Lordship, if Your Lordship may also refer to the case of Coffee Board given on flag 2, page 7 of the compendium.
You are trying to say that it is not for the enforcement of any fundamental rights under Part 3, and therefore it's not maintainable.
Indeed, Your Lordship. The petitioner has failed to prove that which fundamental has been violated in the present case. Your Lordship, if the bench may refer to flag 2, page 7 of the compendium, in the case of Coffee Board, the Supreme Court again held that a preliminary objection was taken at the hearing that the petition do not lie since no question of a fundamental right is involved. Your Lordship, it is in this light of cited precedents, the council substantiate that since no fundamental right has been violated of the petitioner, be the People for Constitutional Ethos NGO, the social activist and the advocate, thus there is no maintainability.
Whenever you are citing a decision, you will have to say which is the citation. You cannot simply say Coffee Board.
Council pleads ignorance, Your Lordship.
No, we are only just, that is the way in which it is to be argued.
Obliged, Your Lordship. Lordship, moving further regarding the maintainability of petition under Article 131, which has been filed by the state of Himachal Pradesh. Your Lordship, Article 131 says that only when a legal issue is in question, not a mere political issue arises, the maintainability under Article 131 is entertained. If Your Lordship may refer to the case of State of Bihar versus Union of India and another given on flag 6, page 15 of the compendium, having citation number 1971 SCC 67, the Supreme Court again held that these words indicate that the dispute should be in respect of legal rights and not dispute of a political character. Your Lordship, in the present case, the petitioner under Article 131 is the state of Himachal Pradesh, which has a government which is in opposition to the ruling government at the central level. This clearly means that no petition other than the opposition party has been filed in the present case, and it is only a matter of political. Nature. Thus, it does not involve the involvement of any.
You
legal
refer
issue.
to the decision in 1967.
1970, Your Lordship.
70.
Yes,
Then
Your
what do
Lordship.
you say about 1970? It's state of Karnataka.
No, Your Lordship. The case cited is State of Bihar.
We
versus-
know. You cited that. The subsequent decision, 78, saying that it is maintainable.
If Your Lordship may again.
You must expect that when you are citing a decision, a later decision, if it is lays down the contraposition, definitely the court will put that question.
Indeed, Your Lordship.
That is why we say, what is the decision in the other one, that is State of Karnataka versus Union of India, which the other side, they are relying on that. AR 1978, page 68.
Your Lordship, if the same case may be referred to by the Honorable Bench, State of Karnataka versus Union of India, given in flag 8, page 20 of the compendium, given by the respondent.
The simple ratio laid down in that case is if there is an actual constitutional right or dispute affecting the legal rights between a state and the central, it's maintainable. That is what the Supreme Court held.
Your Lordship, but the Supreme Court has also held that the issue that is involved must be of a legal issue, not mere political in nature. In the present case, the counsel substantiates his point that the petitioner who is challenging the present petition is in opposition to the ruling government at the central level. No other petitioner other than the opposition government has filed any kind of petition challenging the constitutional validity of one nation, one election. Thus, Your Lordship, the counsel substantiate that since the matters only involves the nature of a political matter, the maintainability.
Are you canvassing the positions that merely because some of other political parties are not challenging it, a challenge which can be maintained should be thrown out by the court simply because that court has to take the position that since the other political parties are not joining the dispute, not joining the litigation, it is purely political. The question is whether once the challenge is against the bias of this and saying that it is unconstitutional, whether that is to be looked into, whether that challenge is maintainable should be looked into based on that. Not whether the color of that political party or the color of the politics of that particular petitioner. That is irrelevant.
Certainly not, Your Lordship. The council has just referred to the point that no other party other than the opposition has filed the petition just for the satisfaction and the reference of this court. The main point behind this is that the political party which is on opposition has filed the petition which involves only a political matter, not any legal issue. If Your Lordships have no further question, the council would like to move to issue number 2. May the council move to issue number 2. Lordship, the issue number 2 before us is that whether the ONOE policy, that is one nation, one election, is constitutionally valid or not. Your Lordship, the ONOE bill was passed through proper legislative framework. Your Lordship, in the facts of the case, it is mentioned that the 129th Constitutional Amendment Bill and the Election Synchronization Bill 2024, they both were passed by both the houses of the parliament, further signed by the president and also published in the official gazette of the India. Your Lordship, such kind of procedural framework which has been followed by keeping in mind the constitutional ethos of the country of Krontika means that the facts also mentioned that the ruling party lacks a 2/3 majority. The passage of bill clearly reflects that there is a bipartisan support by other parties as well, whether be it in opposition or any other alliance party. Your Lordship, if Your Lordship may refer to the case of Babulal Parati versus State of Bombay, given on flag 10, page 25 of the compendium, it states that no bill for the purpose shall be introduced in either house of the parliament except on the recommendation of the president and unless where the proposal contained in the bill affects the area, boundaries or name of any of the state, the bill has been referred by the president to the legislature of that state for expressing its views thereon. Your Lordship, it is in this light of argument, consultation by the state is only mandatory if it affects their jurisdiction. Your Lordship, in the present case, the council would be substantiating in the next issue that the very idea by the petitioner that the country of Krontika is federal in nature is wrong. Your Lordship, now I would like to draw the court attention to what constitutes the term of the Lok Sabha and State Assembly election as per Article 83 and 172 of the Constitution of Krontika. Your Lordship, both the articles say that the duration of the Lok Sabha and the State Legislative Assembly shall be 5 years unless dissolved earlier. Your Lordship, the petitioner has contended that if a period of less than 5 years is given to a is given to a government, then it will violate their right to have an accountable government. But Your Lordship, the constitution nowhere explicitly mentioned that it cannot have a period of less than 5 years. It just says that it cannot have a period of more than 5 years. Your Lordship, thus the validity of ONOE is in consonance with Article 83 and 172 of the Indian Constitution. Your Lordship, if Your Lordship may refer to the Draft Law Commission Report 2018 given on if Your Lordship may firstly refer to the report given by the Law Commission of India, which recommended certain measures to prevent the overhauls of the governance in 1999. Your Lordship, it suggested that at the central level, holding synchronized election to the House of the People and State Legislative Assembly will cause the will stop the policy paralysis that happens due to stagnant and multiple elections. If Your Lordship may also refer to the point that the ONOE also proposes the implementation of single electoral roll. Your Lordship, a single electoral roll aims to consolidate the database of the voters into one unified database. Your Lordship, as the matter of citizenship clearly lies in list 1 of the Crontigan Constitution, which is the union list, where only the union government has the power to legislate upon. The state government cannot give the argument that the principle of federalism is being violated, and we are not having any right to substantiate on this policy matter. Your Lordship, if Your Lordship may refer to the flag 14, page 37 of the compendium, which is the Indian Franchisee Committee report. Your Lordship, it is stated that there is also compilation that it is the present practice to hold elections both for the provincial council, for the legislative assembly on the same days. Moreover, it also says that if elections are held at multiple times, it will include it will have financial burden on the economy. And the highlighted part of the report says that to duplicate the whole process at different times, such kind of holding of simultaneous elections should be entertained and should be maintainable. Your Lordship, additionally, the Department Related Parliamentary Standing Committee report, again in 2015, gave a report which is given on flag 5, page 44 of the compendium. If Your Lordship may kindly refer. Flag 5, page 44. Your Lordship, flag 15, pardon Lordship, flag 15, page 44. In the report, the report is stated that it has stated that simultaneous election would reduce the disruption in governance, as governments would not be driven by populist measures and would not be hindered by the implementation of the model code of conduct, reduce the burden on the exchequer, increase the voter turnout, and reduce the burden on the staff from various government departments. Thus, Your Lordship, if simultaneous elections are held, then the country of Krontika will lead a path to a high economic development. Your Lordship, also Niti Aayog has in its report in 27 established that simultaneous election would foster a balanced growth on both national and regional issues. If Your Lordship are satisfied with issue number 2.
Understand, when the constitutionality of a particular provision is article, the amendment brought into Article 83 and the other provision, when they are challenged, how can you defend it on the sole ground that it will save the financial burden?
Your Lordship, in the country like Krontika,
can that be an element which is to be taken into account at all when the challenge is based on this constitutionality?
Your Lordship, to challenge the constitutional validity of a particular matter which is constitutional in nature, all the broader aspects should be taken into consideration. This is what the contention of the respondent is. In a country like Krontika, having such a huge populous nation, the financial matter is of utmost importance, and it is a matter of national importance, which also lies ultimately with the union government.
We think that you have closely followed the argument so far the other side,
Indeed,
the petitioners. They said about the violation of Article 368 too. You are so far, you are not actually addressing on that issue. That is a main issue.
Your Lordship, the Council has already argued in second issue that 368 clause 2 says that if there is any matter which also legislate upon the matters of state, the ratification by states has also need to be taken into consideration. But your lordship, the facts of the case itself mention that the bill has been passed by both the houses, it has got the assent of the president, and it has also been published in the official gazette of India. These facts clearly imply that the procedural aspect of article 362 clause 2 has also been followed. If your lordship don't have any further question, the countess would like to move to issue number 3.
Are you of the view that the State Election Commission is not having any autonomy?
Your lordship, the State Election Commission certainly has its autonomy under list 2 of the Crontican Constitution, in which only the state government has the power to legislate upon. But this is for the satisfaction of this court, the council would like to move to issue number 2, where the council would answer the question by the honorable bench. Your lordship, the petitioner contends that the country of Crontica is federal in nature. But your lordship, this is clearly a misnomer and misconception by most of the people, in the present case petitioner. Your lordship, it has to be kept emphasis on the point that article 2, 3, 4 of the Crontican Constitution empowers the Union Parliament to alter a state boundary, territory, and even remove a state from India's map just by a single majority. Your lordship, such provisions, along with the vesting of residuary powers only in the hands of Union, make it difficult to classify the Crontican Constitution as purely federal. Rather, it is quasi-federal, having a unitary character and biasness to the Union government. Your lordship, moreover, the Crontican Constitution divided the nation into states only for administrative efficiency. If the honorable court may focus on the Constitutional Assembly debate, where B.R. Ambedkar pointed that the division of the country into further states is just for administrative efficiency, and to prevent further any kind of succession. The states are always the agents of the union, not independent functionally bodies. Your lordship,
why you are referring to Ambedkar's? Because you see here the amendment brought by, it is not by Union of India. The Parliament of Union of India, it's no.
Your lordship, the amendment has been brought by the Union of Crontica, which is the.
So where is the question of that?
Your lordship, whether a policy is.
Are you canvassing the position that observations, the remarks of Ambedkar have some relevance with respect to this question?
Your lordship, the council substantiate that whether a particular policy matter is of relevance to the country or not has to be taken consideration into mind, keeping the legislative intent behind the framing of the constitution. The B.R. Ambedkar gave this point by giving the logic that the main legislative intent behind also enacting Article 1 of the Constitution, which says that India, that is Bharat, shall be a union of state. It has deliberately avoided the term federation, which means that it has to avoid the tendencies of succession and to avoid the tendencies of succession in future after independence. Such kind of term has been deliberately avoided in the Article 1 of the Constitution itself. Thus, your lordship, legislative intent has to be kept in mind.
So, you attempted to canvass the position that this amendment, the challenge against the amendment, it is actually beyond the power of judicial review of this court.
Pardon, lordship, can you again repeat the question?
Are you saying that this is beyond the power of judicial review?
No, lordship, the policy is definitely subjected to judicial review. But the respondent by citing that the policy is consonant with Article 83 and 172 of the Constitution. Moreover, it has economic benefits and other benefits. Thus, it is valid.
Yes, thank you.
If your lordship may give 1 minute extension for completion of the last issue.
1 minute.
Yes, your lordship. Your lordship, fourth issue is that whether one nation, one election restricts citizens' right to have accountable government, minimizing the frequency of elections or not. Your lordship, in the present case, simultaneous elections offer convenience both to the voters as well as the authorities. If your lordship may refer to flag 22, page 66 of the compendium. The Commission in 1982 recommended that holding simultaneous elections to the House of People and Legislative Assemblies of State has following benefits. First one, considerable saving on the collegial available administrative, substantial economy through revision of electoral rolls, civilian personnel running into about 25 of officer and staff, these kind of process are halted when non-simultaneous elections are conducted. Also, there is a duplication of expenditure incurred by the candidate and political parties, which results in pumping in of the considerable resources. Moreover, Your Lordship, it also hampers.
You have to conclude.
30 seconds, Your Lordship. Moreover, Your Lordship, one nation, one election also is also beneficial because of the imposition of model code of conduct, which hampers the policy, and ultimately leads to paralysis in the effective governance of the government. To cite the last point, if the Honorable Court may refer to the fact that in 1999, Karnataka, Maharashtra, Andhra Pradesh, where simultaneous elections were conducted, and an increase of 11.5% was seen. It was indeed an honor argument with the Honorable Court.
In rebuttal, what you want to say?
Hello. Yes, Your Lordship. Your Lordship, as per the contention made by the Council on behalf of the respondent, stating that the Indian Constitution has a unitary nature of the application, but SR Bommai versus Union of India, which has clarified or looked into all aspects of the Indian Constitution, as well as the debate that has taken place during the Constitutional Assembly, finally stated and emphasized that the federalism is not merely an administrative convenience, rather a constitutional necessity. In addition to that, there was a contention made.
Bommai case is not a different 9-judge bench decision you are referring to.
Certainly.
That is because of the dismissal of 6 governments, state governments,
Certainly.
and the dissolution of the constitutional the assemblies.
Yes, Your Lordship. In this particular aspect, I'm referring that in this context where the federalism principle is not was totally vitiated by the certain. 1 minute, Lordship.
We will not put any question now.
Give me 10 minutes seconds, Your Lordship. Let me recollect my thought. Your Lordship, in this particular juncture, the council, on behalf of the petitioner, humbly argues before the court that the SR Bommai has looked into the aspect, and we are emphasizing the key reasoning behind the judgment, which stated that it is not merely administrative convenience, rather a constitutional necessity. And as far as to respond to the allegation made regarding the politically motivated petition, this particular petition is, Your Lordship, violation of Article 368, Clause 2, which clearly states that you need state ratification, and the amendment cannot be held constitutional if there is no state ratification, when the interest of state is being violated. If that is not a legal question, and I don't know what aspect of it would be a legal question, and in addition to that, Article 172, which guarantees 5 years term to each and every state assembly which has been formed in a democratic process. So if violating the same is again the legal question. And finally, Article 243 ZA plus Article 243K, which allows the State Election Commission to be formed and perform elections for the purpose of Panchayat as well as municipalities. Your Lordship, the Election Commission of India cannot act as a delegate of State Election Commission and conduct elections for the municipalities and the Panchayat, Your Lordship. And that would mean that totally violating or surpassing the constitutional power that has been provided to the State Election Commission. And pertaining to that area also, the State Legislative Assembly, State Legislative has the power to appoint the Chief Election Commissioner of the State Election Commission, as well as the State Election Commission must act in the conference with the laws made by the State Legislature, Your Lordship. And if all of this is not a part of the legal question or legal right of the states, at no point in time it's ever been their political motive that has been clearly explained in this particular juncture, Your Lordship, and that's the humble submission. So the one nation, one election policy, which is the 129th amendment, Constitution bill shall be held unconstitutional as per this bench convenience, Your Lordship.
Your Lordship, the petitioner has clearly failed to establish their point. Their point remains completely invalid and baseless. Your Lordship, they said that in their written submission that the Article 356 can be prone to misuse. Your Lordship, I would substantiate for the benefit of this court that federalism is violated when the same political party in the past has imposed emergency under Article 356 for 2.5 years just for their political vendetta. The ONOE says that it is a one-time reset button, and after that, no further hindrance can occur in the simultaneous elections. Your Lordship, thus, That's why ONOE says that the new government which will be formed after the dissolution of the state assembly or Lok Sabha will only function for the unexpired period, not for the period of 5 years, which is also substantiated by the respondent that the constitution says that the period shall not be more than 5 years, but however it can be less than 5 years. Your Lordship, the petitioner has also failed to prove that how Article 14 and 19 of the constitution is being violated in the present case. Your Lordship, the petitioner has also contended that the ONOE policy, since it mandates the use of Article 368, should be used as a last resort. But according
Also, in the case of PUCL versus Union of India, the right to vote is a fundamental expression of democracy. If the elections are rare, and people will lose their opportunity to elect their own representatives, and there is a chance that the elected representatives, if they are elected for 5 years, they will not be they will be complicit in their issues, as they are.
Where is the chance of a deprival of the power to elect your representative?
Pardon, Your Lordship.
You said about this deprivation of that right to vote. Where is the question of a right to infringement of that right?
A right to vote means that right to vote, it should not have any sort of force on the people. If the state and the national elections will be
See,
held at the
what all
same
right
time,
was with a citizen, that will continue to be there. There is no taking away of any of those rights.
Your Lordship, when the state and the National Assembly elections will be held at the same time, the people will not be able to decide what government has to take, like whether the national issues have to take precedence or state issues have to take precedence. Therefore, there will be a force on the part of.
See, that very voter, he would be getting a right to vote and he can elect who should be. It is for you to decide who should be your MP and who should be your MLA. So there is no question of depriving any right of that.
The council seeks ignorance of these issues. Issue number 3 deals with whether the erosion of federalism and regional representation is taking place, whether the one election infringes the independence of the state legislature by enforcing uniformity in the state elections. My humble submission before this honorable court is that it is eroding the federalism, which is the basic character of the constitution, and also the regional representation. If the national if the national elections and the state elections will be held at the same time, the people will not be able to decide whether to elect the national representatives or whether to elect the ruling party or the state party in this case. The national issues will take precedence over the state issues, and therefore it will be it will lead to the erosion of the federalism, which is a basic character of the constitution. My second submission before this honorable court is that when the one nation, one election is against the democratic principles, because
1 minute you will have to conclude.
It is imperative for the regular and timely elections for the democratic accountability, because in this case there will be unwarranted delay in the state elections, and because it will be held after 5 years, therefore it will lead to the grave injustice in this case. If your lordship may, can I proceed with the issue number 4? The issue number 4 deals with whether the one nation, one election restricts the right of citizen to have.
See, you said about the right of the particular voter. Suppose if the government is dismissed, as has been done, you must have gone through the decision in Bamei's case, or a dissolution of an assembly, there also this kind of a situation would arise. So can you say that there is an indivisible right for a person who is elected by the people to continue there for 5 years? Any such indivisible right is there? Whether it is that question to be addressed or any other particular question to be addressed in a case like this. What exactly is the question to be looked into?
It is a deliberative act that the one nation, one election has been imposed. Otherwise, in case of the dissolution of the state assemblies, it is not a voluntary act in such cases. It is leading to subjective circumstances. If I have to refer to fourth issue, is that whether the one nation, one election restricts the right of the citizen to have accountable government by minimizing the frequency of the elections. My humble submission is that the adverse impact on the federalism and regional representation would be there, because of the thing is, if you refer to the 2024 elections.
Now in 1 minute conclude your argument. No?
My humble submission is that monetary value cannot take a value over the constitution values, because even if there is one nation, one election, and the monetary value is argued that the monetary value has to be taken precedence and it will save the resources.
Who argued? Nobody. Nobody argued that.
There have been arguments. Yeah.
Okay.
If I can take 2 minutes of the court's precious. My third submission is that even if the economic benefits are there, the one nation, one election are just voodoo economics. For example, even if like one nation, one election has to be there, the resources for the resources which are needed for the one nation, one election are really like they are like, for example, if we take the case of UP election only, there have to be so many manpower over there, so many EVMs over there, and also it has to be conducted under various phases, and it is not possible that the one nation, one election can can lead to the economic benefits of the country, because one nation. If we
Election Commission got no such case that it is impossible to conduct an election.
My humble submission is that the economic benefits of the one nation, one election.
Go through your brief. You do not have any such case. The case is on a totally, you are challenging it on a different ground.
My fourth submission is that model code of conduct will not impact will have no impact on the governance, as these are temporary and short-term measure and only relevant during the election period. Thus, MCC requires schemes to be undertaken by civil.
Yes, that point we got. That is the model conduct. It will be for a short time. Therefore, it cannot have any impact at all. Any other?
Also, the MCC requires like if the if the act has to be brought in that period with the permission of the Election Commission of India, it can be brought with during the phase of MCC. Therefore, the MCC will have no impact on the governance. The one nation, one election defeats the anti-defection laws of the country, because if the government is formed from the unexpired period following the dissolution of the assemblies or the parliament, then it will lead into encourage. If your lordship hasn't satisfied with the 4 issues, the council would like to proceed towards the prayer. In the light of the issues raised, arguments advanced, and authorities cited, it is most humbly and respectfully prayed before this honorable Supreme Court that the present petitions under Article 32 and 131 are maintainable, and the acts passed by the Parliament of one nation, one election are unconstitutional in nature. The one nation, one election infringes upon the independence of the state legislature by enforcing uniformity in the election cycles.
Yes, thank you.
It was an honor arguing before this honorable court.
Yeah,
Your Lordships, the Council on behalf of the Respondent, MP16, in the case of People of Constitutional Ethos and Sinchal Pradesh versus Union of India is representing Union of India. If the Honorable Bench is aware of the facts, I would like to proceed with the issues. Yes. Much obliged, Your Lordships. Issue 1, whether the present petitions are maintainable. Your Lordships, the respondent contends that the present petitions are not...
Understand one thing, that is why we said at the outset, are you having a case that it is not maintainable? Then you will have to say it is not maintainable, and then you should give the reason why it is not maintained. It cannot be, it is not maintainable. We never put a question to them. That is why we said, you need not argue that point.
Okay, Your Lordship.
So it is for you to say it is not maintainable. Why?
Yes, Your Lordships. We are stating that they have filed the case under Article 32, and we are stating that Article 32 can be filed only if the fundamental rights are being violated. And we are stating that none of the fundamental rights are being violated, and coming to the point of the golden triangle. Article 14 is not being violated as it is making a reasonable classification, Your Lordships. We can clearly see that there's an intelligible differentia with a nexus to its objectives, Your Lordships. The objective is to reduce the massive election expenditure and the policy paralysis which results from the model code of conduct and the burden of the crucial manpower which is required multiple times if there's frequent elections.
See, take that it is not maintainable under Article 32. What is your contention with respect to the maintainability in the light of Article 131?
Yes, Your Lordships. Under Article 131, the Council submits that according to the precedent in the case of State of Karnataka versus Union of India, where Justice Bhagavati has stated that Article 131 can be invoked only when the dispute concerns existence of an extent of a legal right which exists irrespective of the right being violated. Your Lordships, the petitioner has just contended that the federalism is violated without any enforceable legal right that has been violated, Your Lordships, through the process of ONOE. And Your Lordships, in the case of Kuldeep Nair versus Union of India, where the court has already clarified that federalism, while a part of basic structure, does not provide justifiable rights that can be enforced through Article 131, indicating that mere ideological and structural concerns do not satisfy the requirement under this provision. Your Lordships, Article 131 is concerned with intergovernmental disputes where the rights and obligations of the union and state are in question. And constitutional challenges like this should be under Article 32 and not under Article 131, Your Lordships. And the petitioner fails to show how ONOE alters the stated constitutional position in manner that infringes upon its rights, Your Lordships. If the Honorable Bench is contended with my argument, I would like to proceed to issue 2. Your Lordships, I would also like to cite the case of...
You must understand one thing.
Yes,
the question whether any court is contended with what was argued will be reflected only in the judgment.
Okay,
No court will say, yes, we are accepting this and therefore.
Okay, Your Lordships.
If you are satisfied, you can move on to the next one.
Your Lordships, one last case I would just like to cite is case of Madhya Pradesh versus Union of India, where it is stated that the constitutionality of central legislation cannot be challenged under Article 131, but rather must be made under Article 32 or Article 226, which are the designated remedies for such matters. With the permission of the bench, I would like to move on to issue 2. Your Lordships, issue 2 deals with whether the acts passed by the Parliament for ONOE are one nation, one election, herein after referred to as ONOE, are constitutionally valid. Your Lordships, the Council contends that these acts passed for the one nation, one election policy are constitutionally valid as it has a very huge impact, such as the reduction in massive expenditure that is incurred due to frequent elections, the policy paralysis that results from multiple applications of model code of conduct during the election time, and the burden on crucial manpower that is deployed during the election time, and the increase in circulation of black money. And Your Lordships, all of these points are a matter of national interest, and hence it is very important to make this amendment, Your Lordship. I would like...
Understand this. Suppose the main focus of the petitioner is that, or rather they were trying to say that this amendment virtually violates the basic structure.
Yes, Your Lordship.
If it actually violates the basic structure, whether the other questions, whether it will save the time or whether it saves the finance, etc., they are inconsequential. They will pale into insignificance.
Yes, Your Lordships.
So first of all, say that how you will address this issue.
Yes, Your Lordships.
Their core contention is that it violates the basic structure.
Yes, Your Lordships.
Why you are saying that it will not?
Yes, Your Lordships. The acts passed by the Parliament are in accordance to the doctrine of basic structure, Your Lordships, and we are contending this because firstly, coming to the point of federalism, Your Lordships, we are using the main contention why it is violating federalism is that stating that the premature dissolution that has to happen once. For making sure that the simultaneous elections will begin, that premature dissolution is causing to the violation of basic structure, Your Lordships. That is the contention. And we are stating that we are using the doctrine of expansion and doctrine of reduction for these eventualities of extension and dissolution of the House for the expiry of the term, Your Lordships. This was also stated by Justice Deepak Mishra, former Chief Justice of India, in his meeting with the high-level committee, Your Lordships. And we would also like to state that India is not a federation, but rather a quasi-federal structure, Your Lordships. And now what is very important to understand is what federalism that we have in India.
We are not concerned with India in this case.
I apologize, Your Lordships. Krontika, in the country Krontika, Your Lordships, now to realize what was the meaning of the federation which is there in the preamble. It is very important to understand the intent of the drafters and the founding fathers. Your Lordships, Dr. B.R. Ambedkar highlighted the character of the Krontikan constitution where the federalism states and the drafting committee wanted to make it clear that Krontika was to be a federation and the federation was not a result of an agreement by the states to join into a federation and that the federation is not a result of an agreement. In the sense, Your Lordships, unlike the United States, we are not different states who have come together for a common country, but rather it is one country which has been divided into small states for the comfort of administration. Your Lordships, it is very important to notice, since they have specifically stated that the people may be divided into different states for the convenience of administration, what we can conclude from this is that federalism is like a principle and not a structure. And federalism is not just about the legal division of powers, but also about the governance principles like local autonomy, regional expression. Your Lordships, what we are contending is that through this, federalism will not be affected because even after the amendment, the state's autonomy is still retained to have its own jurisdiction where the state governments will represent their states and they will make sure that they look after all the problems which are happening in the state. And the center is not controlling the state. The state still has its autonomy, and that is why we are contending that it is not a violation of federalism. Your Lordships, now regarding the democratic principles. The democracy is about the right to vote, free and fair elections, and good governance. And Your Lordships, none of these are being violated and neither of the grounds are actually mentioned by the petitioner but merely just stated that democracy is being violated. Your Lordships, this does not infringe on the citizens' right to vote or the democratic process. Instead,
in the context of this case, this particular case, how should we, in what manner we should understand the other expression, though they have not actually used that expression, and democratic?
Your Lordships, what we are contending is making simultaneous elections does not make the constitution's democracy undemocratic, or making the frequent elections into simultaneous elections does not mean we are becoming anti-federal, Your Lordships. All the rights under democracy are still being upheld by this amendment, Your Lordships. Even in the case of Koholto Holan versus Ziluchu in page number 17, if you may refer, where the Supreme Court held that democracy is based on the idea of free and fair elections, but it also implies a system of government where the elected representatives remain accountable to the people. It is not merely a mechanical process of casting votes, but the fulfillment of principles of transparency, integrity, and accountability in the functioning of the government. And your lordships, what we are stating is by bringing one nation, one election, all these will actually be upheld where we can see the accountability and transparency of the government, state governments, your lordships. With the permission of the honorable bench, I would like to proceed to issue 3. Issue 3 is whether the one nation, one election infringes on the independence of the state legislature by enforcing uniformity in election cycles. Your lordships, the council contends that it does not infringe on the independence of the state legislature by bringing these amendments, because lordships, first I would like to state that this is not just brought for the state government, but rather on a national interest. This is made on a much bigger scale and to bring reduce the expenditures.
Understand one thing, when you are defending a case like this, you should be knowing and you should be saying what is the actual position, or what was the pre-amendment position of this very particular article.
Yes, your lordship.
And what is the impact of the amendment, and or in other words, what is the amendment, and then why it is not, why it is constitutional.
Yes, your lordships. Your lordships, first I would like to talk about the original position. Your lordships, it is very important to notice that in our constitution originally, what was intended by the constitution was to have simultaneous elections, your lordships, and not frequent elections. Frequent elections was something that happened later due to disruptions in the governance. And what one nation, one election policy does is it brings an amendment act which tries to bring back the constitutional values which actually intended for having synchronized elections. And this one nation, one election policies and amendments also talk about how we make sure that this synchronized elections continue and are prolonged even in the cases of dissolution of houses and any other emergency cases. And your lordships, it is very important to notice that even in such cases, there is no presidential rule, your lordships. We are conducting elections again for the unexpired term, your lordships. And that all these amendments are brought under the parliamentary competence, your lordships, as we can notice in Article 327 and 328, which shows that the parliament has competence to make the amendments for the state legislature as well. And state legislature has the power to bring legislative laws for elections, but it is submissive to the constitution and the parliament, because the parliament looks at the national interest. And your lordships, in this we are not infringing on the state interest, and everything is being well versed, highly discussed, and then brought into force, your lordships. And even under your lordships, it is very important to notice, as the petitioner has contended that people do not have enough mind to decide what is the difference between the state government and the central government, your lordships. But here they're backing empirical evidence, your lordships. In 2019, we had simultaneous elections, your lordships, and in 2014, the general elections and the state elections which coincided in Odisha and Aurangabad, yet the regional parties such as BJD in Odisha, INC in Arunachal Pradesh retain their powers to state level. This shows that people can differentiate.
Again, understand that there is a dilemma. It appears that there is a dilemma. You appears to have under the impression that the question here, the dispute here is with respect to an amendment brought in by the Parliament of India. That's not the way in which you will have to argue.
I apologize, your lordship.
You refer to about, we never want to say anything about any,
Your lordships,
refer
actually,
the name of any political party, but you refer to the name of a particular political party,
yes,
which is only in India.
Your lordships, actually.
And therefore, no, why we are saying this, whenever a case is there, you should be knowing what exactly is the case.
Yes, Your Lordships.
Please proceed.
Your Lordships, actually, the Council is well aware of the fact that you have pointed, but the only reason we have stated this is because all the laws and political situations are in pari material to that of India. So just to give a small reference, this has been put and no other reason, Your Lordships. But now I would like to continue with the argument, Your Lordships. Your Lordships, we contend that the state-specific issues drive regional issues, where the state elections are driven by the local governments and regional developments and leadership rather than national narratives, and that the state parties, which do not necessarily align with the central parties, are still winning the cases, still winning the elections, Your Lordships. With the permission of the Honorable Bench, I'd like to proceed to issue 4. Much obliged, Your Lordships. Whether ONOE restricts the rights of citizens to have an accountable government, minimizing the frequency of elections. Your Lordships, we contend that this does not curtail the citizens' rights to an accountable government by minimizing the frequency of elections. Instead, it aims to enhance governance by upholding the democratic principles. This policy is designed to streamline the electoral process without compromising on transparency, public participation, or governmental accountability, and this strengthens the national unity, Your Lordships. It prevents a state-centric division, ensuring that the citizens of Krontika elect representatives simultaneously, promoting a unified national identity. ONOE optimizes financial and administrative resources, preventing frequent governance disruptions. Your Lordships, in the case of Union of India versus Harbhajan Singh, in page number 23, if you may refer, the Supreme Court held that the Krontikan Union is a single political entity, and that any action or law that undermines the unity of the nation would be contrary to the spirit of the Constitution, Your Lordships. Your Lordships, in the Election Commission of India, in its first annual report, and the department related to Parliamentary Standing Committee on Personal and Public Grievances has also stated that simultaneous elections for both the Houses of People and State Legislative Assembly are needed. And they have stated that the...
Any such a report from the Election Commission of that particular country? You referred about the report of Election Commission of India.
Yes, Your Lordships, but since...
We are dealing with the amendment brought in by the Parliament of another country.
Yes, Your Lordships. We are intending of Krontika. I apologize, Your Lordships. Since it was in pari material, it was used, Your Lordships. But now we are talking about...
Even if it is pari material, that is the provision.
Yes, Your Lordships.
The question is, you refer to a report of the Election Commission of India.
Yes, Your Lordships.
Whether the Election Commission of that particular country is also... Is it there? There is no reference.
Yes, Your Lordships. I am referring to that of Krontika. I apologize, Your Lordships, for the mistake committed again.
So you do not have, we have gone through this, you do not have such a case that now similar to the report of Election Commission of India, another report is there.
Yes, Your Lordships.
You did not refer to anything like that.
Yes, Your Lordships.
Then what is the relevance of this?
Your Lordships.
Then what is the relevance of this submission?
I would like to repeat, Your Lordships. The Election Commission of Krontika, in its first annual report, and the department related to Parliamentary Standing Committee on Personal Public Grievances, Law and Justice, advocated the idea that conducting simultaneous elections for both the Houses of People and State Legislative idea, stating...
So just like the report of Election Commission of India, there also there is such a report.
Yes, Your Lordships.
That you did not say. Now you are saying.
Yes, Your Lordships. Much obliged, Your Lordships, for correction. They have contended that the simultaneous election is the rule and frequent election should be the exception. And they have also contended about the compelling reasons why we should have this, which are as follows, Your Lordship. It would reduce the massive expenditure. Your Lordships, may I take 2 minutes to conclude?
Why can't it be in 1 minute?
Absolutely, Your Lordships. I'll conclude it in a minute. it would reduce the massive expenditure used to conduct separate elections every year, Your Lordships. And they've also talked about the policy paralysis that would result from the imposition of model code of conduct during the election time. And that during the elections, whether the Lok Sabha or the assemblies, the entire administrative setup throughout the country slows down considerably. And that the normal function and activities of the government, including the developmental work, and are pushed to the background, because now what is on the focus is the elections, and that this will also impact on a delayed delivery of the essential services, and the burden on crucial manpower that is delayed during the election is almost 25 lakhs for elections, and making it multiple times will just make the work of the person double, and that their actual work will go to the sideline, Your Lordships. And that there are a lot of global examples where countries like Germany, South Africa have conducted simultaneous elections and are making a progressive reform, Your Lordships. With the permission of the Honorable Bench, I'd like to proceed to the prayer. Wherefore, in light of the facts presented, issues raised, arguments advanced, and authorities cited, the Council on behalf of the respondent most humbly prays the Honorable Court to adjudicate and declare that to dismiss the petition as they are violating the constitutional provisions. The court may be pleased to declare the one nation, one election policy as constitutional, and the court may be pleased to direct the petitioner to the cause of the present petition and pass any other order that this honorable court deems fit, and pass any other order or orders that this honorable court deems fit in the interest of justice, equity, and good consciousness. And for this act of kindness, the respondent shall forever humbly pray.
Yes.
Council seeks permission to address the dais. My first bone of contention against the learned respondent is that she stated that the act falls, that the one nation, one election respects the reasonable classification, but the rational nexus stated that it is cost effective.
The council never used the expression classification.
She indeed used, and she also stated
where is the question of classification here? Nexus.
She also used the national nexus that the economic resources will be saved under this election. But the thing is that the economic resources, even if we consider that one nation, one election has been there, the resources at the one time can be more than what this can be more than if the elections are held and periodic elections are held, because it requires a lot of manpower, it requires a lot of EVMs into consideration, and even if we consider the UP elections, as I stated earlier, that it has to be there under various phases. But how will the one nation, one election can be possible if even the state assembly elections cannot be held with economic resources? My second bone of contention is that the respondent stated that any law passed by the legislature is both a benefit for the people and is the best decision maker. However, the petitioner has already proven that it is violative of the basic structure.
See, if you are conducting a short survey of the decisions of the Supreme Court right from 1951 to 1973, whether this kind of an argument or based on this economic issue, financial issue, is available to challenge a constitutional amendment.
Financial, as every law has been passed because of the societal issue, on the basis of the society, therefore economic resources can be one of the main contentions. As she already stated that the economic resources as a rational nexus, as the economic resources will be stated, I was demystifying that the fact that even if one nation, one election...
That is why we are asking this question. Whether this is it a matter, is it a ground available to challenge the constitutionality of any amendment?
Every law has been passed because of the...
See, why should you argue? That is their contention. In rebuttal, what you want to say? Your main contention is that that cannot be an issue at all, because you said about the unconstitutionality of this amendment, and therefore this cannot be defended by merely saying that this will save the finance. Move on to the next.
My second submission is that it is violative of the basic structure and is withholding the federal structure of the country. And even if we take the respondent's contention into consideration, the election falls under the, even though the election falls under the union list, but it does not take into account the panchayats and the municipal bodies which are under the state list under entry 5. And if the union is not fit to make laws over it. Also, how can a person compare the population of the other countries with that of India? Because every country has its own own demographic structure, and on the basis of that demographic structure, the laws are made over there. And also the right to have the respondent contended that under Article 21, the right to have elections at a single time should one nation one election would follow it. But even if we take that Article 21, but right to participate in elections is merely a legal right and not a fundamental right. That's all.
Not it was an fundamental right according to you. It's only a legal right, not a fundamental right.
A right to participate in elections is a...
You see, you are for the petitioner, you are saying that it is not a fundamental right. If you yourself admit the position that there is no you are here not for enforcing any fundamental right, how can your petition can be maintained under Article 32? You are not for the other side. You filed the petition under Article 32 and you yourself admit the position that you are not here for enforcement of a fundamental right. Then how your petition can be maintained?
Council seeks its ignorance.
Slip of a tongue?
Yes. It was an honor arguing before this honorable court.
Anything you want to say in rebuttal?
Yes, Your Lordships. Firstly, I would begin with the response for the rebuttal that they have made, that the economic sources are, they have said that the economic ground is the only ground that we are contending on, and that is absolutely false, Your Lordships. The economic ground is a contention of ours, as it is a very big amount that has been deployed in simultaneous...
Irrespective of the ground, if it is found that this is unconstitutional,
yes, Your Lordship,
on the other grounds,
yes, Your Lordship,
because it violates the basic structure,
yes, Your Lordship,
then why should we look into the other question at all?
Your Lordships, one very important thing I would like to contend is that I have explained entirely of how it is not violating the basic structure, being the respondent, and the petitioner is not stating how it is violating the basic. They're just merely stating it is violative of basic structure, Your Lordships, and have no contentions on how it is violating the basic structure. Hence, I didn't start with that contention, Your Lordship, because I am with the presumption that it is not a violation of basic structure.
You know that in our setup, even though that is not there, a matter like this, the court can also put a question.
Yes, Your Lordship.
Here, why you are saying that it is constitutional?
Your Lordships, since it is constitutional, since it is not violative of the fundamental rights, firstly, Article 14, 19, 21, there is a intelligible differentia with a nexus to its objective.
Leave aside the fundamental rights.
Okay, Your Lordship. Coming to the democratic principles and federalism, Your Lordships, which have been contended, I would like to say that democracy is not being violated. The citizens still have the right to choose their own representatives for their states, and the representatives have the right to contest to the elections, and even free and fair elections, which is an important aspect of democracy, is being upheld. Because through one nation, one election, there will be more accountability and transparency, and there will be an overlook on whether the...
What is your stand on the contention that it is nothing but an intrusion into the autonomy of the State Election Commission?
State Election Commission, Your Lordship. Your Lordships, it is not an intrusion into the State Election Commission, because the Council contends that the independence of State Election Commission has not been violated. In fact, it has been upheld, and the Election Commissioner is the one who will look after the electoral process that is happening in one nation, one election, and through this we can also state that the Union will not be overpowering the state legislature, as the State Election Commission will be making sure that everything is happening in a transparent and a constitutional manner, Your Lordship. If your lordship may permit, I would proceed with the rebuttal. Your lordships, the petitioner has also contended that people can't differentiate between the national and state interest, your lordships, and calling the people immature to differentiate between them, forgetting the empirical background of where people have differentiated in the country Chrontica, your lordships, and that has not been answered, and that regarding simultaneous elections will conduct. Your lordships, they have always stated that simultaneous frequent elections, that they have only contended about happening once. Our entire contention is that happening multiple times is the problem, your lordships. One election.
Understand one thing, it will happen once even according to you.
Yes, your lordship.
Therefore, the question is whether it will not recur. Can that be a ground? When the challenge is that this very amendment is unconstitutional. That is a matter to be looked into. That is what we are.
Your lordships, may you specify into the question once again?
Please proceed.
Yes, your lordships. What we are contending is that this is not unconstitutional because, your lordships, in the case where there is a premature dissolution, there will be a presidential rule in that particular state for a period of time, and later for that unelected, for that rest of the period, unexpired period, there will be elections held again. And in that elections, again, people will have the right to choose their own representatives, considering the democracy, your lordships, and hence it is not a violation of any of the fundamental rights or basic structure in the constitution, your lordships.
One doubt which is passing through our mind is,
yes, your lordships,
you said that the election, if this is upheld, the election to any particular state will be for the unexpired period.
yes, your lordships.
Take a case, in the case of a state, the period was 3 years. In the case of another state, it is only 2. Yet another state, it is 1. So if you are conducting election, this one nation, one election,
Yes, sir.
the election for X state will be for 3 years, the other one for 2 years, again the next one for 1 year. That means
Your lordships, here I would like
same
to...
situation.
No, your lordships,
It will be back to square.
No, your lordships, we are...
How? Because that particular, as regards the X state, the elected government, the elected after the election, that elected government, they can continue for 3 years. As far as the other state, they can continue only for 2 years. Then where will you apply this principle then?
Your
One
lordships,
election, one nation.
there are a few things that are out of the control of the union. But
We
the
put
main...
that question, pointed question only because of your contention that the election, if this principle, if this amendment is accepted or upheld, definitely the election for that any particular state will be only for the remaining period of the assembly.
Yes, your lordships. Your lordships, I would like to state about Article 172, which talks about the duration of the state legislative assembly, where it says that every state legislative assembly, where every state, unless sooner dissolved, shall continue for a 5-year period from the date of appointment from its first meeting and no longer, and the expiration of the said period shall operate as a dissolution of the assembly. Your lordships, the constitution itself is giving the remedy on what will happen in the case of a premature dissolution, your lordships, and in accordance to this, we have made the provision about what it is talking, unless sooner. Your lordships, it is very important to notice that the 5-year period is the limit. But there are chances where it can dissolve sooner, and this has been recognized by the Constitution in Article 172, your lordships, and in accordance to that, we have made the amendment bill, your lordships.
Thank you.
Much obliged, your lordships.
With the Your Lordships, Your Lordships, with the permission of the bench, I now call upon the participants for third round. The third round will be held between MP 16 petitioner versus MP 04 respondent.
The council seeks permission to approach the dais.
Your MP 16 petitioner.
Yes, Your Lordship. If the Lordship is well versed with the facts, the council seeks permission to directly begin with the issue.
You must understand that when you are challenging the constitutionality, you will
Yes,
have
Your
to say
Lordship.
in brief, in succinct, state the facts.
Okay, Your Lordship.
That is art of advocacy. You will have to say in succinct.
Yes, Your Lordship. Krontika is a country which got its independence in the 1947. Its constitution was adopted on 26th of November 1949. Krontika is a country which follows the democratic republic socialist sovereign principles and also the very important principle that is federalism. It follows the quasi-federal federalism which talks about the separation of power. After the independence, there were simultaneous elections. But due to some emergency like the dissolution in the Lok Sabha, emergency situations, those elections diverged and there were separate elections for both general elections and state legislative assembly elections. Now critics argued that these frequent elections were curbing down the expenditure of the election budget. Now in 2019, the People's Constituent Party came in force and they had a good majority from 2019 to 2024. They proposed a bill of one nation, one election, which was talking about through the amendments made under Article 129 Amendment Bill and Election Synchronization Bill. The bill tend to talk about the amendments made under Article 1, Article 82, Article 82A, 173 and 172 and also Article 356 and the Section 315 of the Representation of Peoples Act. Now, due to the sadness caused to the people and the NGO, they have filed a petition in the Honorable Court and therefore, the Council would like to begin with the issues. The Council seeks permission to begin with the issue 1. Issue 1 says whether the present petitions are maintainable. The Council humbly submits that the present petitions are maintainable by the virtue of Article...
Who said that it is not maintainable? Did we?
No, Your Lordship.
Then who?
That is what I'm contending, Your Lordship. It is maintainable. It is maintainable.
Whether the petitioner should argue, unless the court puts that question.
No, Your Lordship.
The other side is yet to address. That is why we are saying.
Okay, Your Lordship.
So you are thinking that it is maintainable.
Yes, Your Lordship.
Proceed the other way. Let the other side raise that contention.
Sure, Your Lordship. So the Council seeks permission to begin with issue 2.
Or else to enable you to argue that point, we will put that question.
Sure, Your Lordship.
How you will maintain this?
The present petitions are maintainable.
You are compelling us to put that question. We will answer how you will maintain
I will answer,
under
Your
Article 32.
131, Your Lordship.
32 also. You are not
32,
referring
Article
to.
32.
You never want to argue on 32?
No, Your Lordship, I'll argue. The present
What is
petitions,
the, which fundamental right do you want to enforce?
all the fundamental rights, the golden triangle, 14, 19 and 21
Why you say all the fundamental rights?
of the golden triangle.
Otherwise, part 3 entire.
No, Your Lordship, of the golden triangle, 14, 19 and 21. Under Article 32, which gives the direct access to the Supreme Court, which is guaranteed under Article 32. Now here, in the case of K.K. Verma versus Union of India, it has also been said that the Supreme Court has the duty to protect the fundamental rights which are guaranteed by the Constitution, and if there is
Better now come to 131.
Okay, Your Lordship.
Don't waste your time because it's only 5
Yes, Your
minutes.
Lordship. The original 131 talks about the original jurisdiction of the Supreme Court, which takes the dispute between the union and the state. And one nation, one election is also a dispute which talks about the union and state, and therefore the present petition is totally maintainable. Now, if the bench is satisfied, the council seeks permission to begin with issue 2.
I do not know whether my brother is satisfied or not.
So can I just take the permission to begin
And
with issue 2?
unfortunately, I am having the habit of not disclosing these things. Whether I am satisfied or not, that will only, it will appear only in the judgment.
I apologize, Your Lordship.
So you will never ever get such an answer from any court.
Okay, Your
The court in the meanwhile will not say, hey, I am satisfied, I am going to allow this particular prayer, you proceed. No.
Yes, Your Lordship.
So if you are satisfied, go to the next point.
The council seeks permission to begin with issue 2. Issue 2 talks about whether the acts passed by the parliament for one nation, one election are constitutionally valid. The council humbly submits that the one nation, one election is not constitutionally valid. As firstly, in the landmark case of Kesa Vandana Bharti versus State of Kerala, which talks about that basic structure doctrine cannot be amended. And one nation, one election is directly hindering the principle of federalism. The amendment made in Article 1, which have changed the union of states into a unitary state, which clearly state that there has been no distribution of power. It is hindering the separation of powers. It is clearly justifying that there is a centralized country and it is dominating the national party. So therefore, it is totally hindering the principle of federalism. Apart from this, the council contends that by the virtue of Article 174 of the Crontican Constitution, which states that the state have the right to determine their own timelines and their dissolution, which also includes the election. But the amendment made under Article 82, 173, 172, these all are pertaining to simultaneous election. The main question which arises here is how the simultaneous elections will be implemented. For the implementation of the simultaneous election, there has to be either a premature dissolution of the Legislative Assembly or there has to be the extent of the curtailment of their time. Now here, in both of these cases, the independence of the state legislature has been hindered. It is against the state autonomy and it is also against the citizens. They are not getting the equal right to have their accountable representation. They are dissoluting their own representations for which they have elected for. So therefore, the council humbly submits that it is against the federalism. Coming on to the point of Article 356, which talks about the president rule, the council humbly submits that in the case of S.R. Bommai versus Union of India, it is clearly stated that 356 is not an absolute power and it should be used very cautiously and sparingly. And all the other options should be taken first, and then only the dissolution should be taken. And if the Supreme Court is satisfied that the dissolution is done through unfair manner, they can either postpone the dissolution or re-establish the Legislative Assembly. The council humbly submits that one nation, one election is not the only solution to curb down the frequent elections, curb down the expenditure of the frequent elections. There are also many other solutions to it, and this is just an election manifesto through which the central is trying to mislead the citizens and gain the dominance in the whole country. There are also other options, like there can be the state-funded donations, the donations to which the parties make, they can be of a specific budget so that they can make it. Other thing that there can be digital e-campaigning. All the private advertisements should be banned. There can be an option for e-voting also. As it is also curbing down the transportation, the cost, and all the cash transactions can be stopped. And there can be only electronic transactions. These all are the methods through which the expenditure of the election budget can be curbed down. One nation, one election is not the only solution to it. Apart from this, the council humbly submits that one nation, one election is also against free and fair election. Article 368(2)(c) and Article 368(2)(d).
See, the main contention is that it violates basic structure.
Yes, Your Lordship.
Why you are canvassing that position? Why and in how? What is the manner in which it violates the basic structure of the Constitution?
Your Lordship, one nation, one election, firstly, it is prematurely dissoluting the Legislative Assembly. One thing. This is again hindering their own power. And it is separate. There is a federalism. The amendment they have made in Article 1, which talks about union of states, they have amended into showing as a unitary state. The amendment itself shows that they are trying to centralize their own power and creating their own dominance.
See, if this is upheld and if election is conducted
Yes, Your Lordship.
based on that, even then that structure will continue.
Your Lordship, but there is a difference.
So that is why we are again and asking this question.
Yes, Your Lordship.
How and why? Why you are canvassing that this will affect or this will actually violate the basic structure of our constitution?
Your Lordship, due to one nation, one election, firstly, the regional parties will also be marginalized because when the elections will be contained.
Where is the question of marginalization?
Yes, Your Lordship, when the dominant parties, when the national parties will be campaigning, they'll have a more budget and there'll be more expenditure.
Are you canvassing the position that the national parties will not contest in the state election?
No, Your Lordship, but
They
this
will.
will marginalize
They
the
will.
regional parties.
So if it happens during the election to the Lok Sabha, this will happen certainly in the other thing also.
But Your Lordship, when there is a frequent election,
That
the
is why you
state-
pinpoint your argument on this issue, why you are saying that it will violate the basic structure.
Your Lordship, it is one nation, one election talks about the simultaneous election. And federalism is a part of the preamble, and preamble is a part of, it is a very important part of our constitution. Firstly, it cannot be violated. Here, true to one nation, one election, there has been a problem in separation of powers. They are trying to make both the state and the union together. Whereas they have both different needs. There are totally different government needs, economic needs, and they work according to their own local conditions. But due to the forcefully uniform election schedule, they will be not able to make an accountable representation to their citizens. It is totally hindering the separation of powers. As because of the one nation, one election, the
Virtually,
citizens...
we are at a loss to understand that contention.
Pardon, Your Lordship?
We are at a loss to understand that contention.
Yes, Your Lordship. Yeah, Your Lordship, in the IDFC Institute report, it is clearly mentioned that whenever there have been a simultaneous election, 77% of citizens have elected the same party. But whenever there has been a divergent elections, only 48% of citizens have elected for the same party.
Can that be a ground for challenging this?
No, but this is a ground which talks about
That is why you know that whenever there is a challenge against an amendment brought to any particular article in the constitution, there are only very, very few grounds are available. So
Yes, Your
why can't you argue within that?
Your Lordship, there are a lot of things which are hindering. Firstly, the equality of the citizens, as when the one nation, one election will be implemented, there will be a requirement of large logistical, operational, security, manpower, equipment, all of these things will be there. And in failure in any of these will disfranchise the ineligible voters, which will be against the right to equality. And also, the premature dissolution of the state is against the state autonomy. It is against their own. It is against the separation of power. Here, not only the state...
As far as election is concerned, one of your, of course, we have gone through your briefs.
Yes,
It
sir.
says that the autonomy of the State Election Commission. Where is the question of infringement of the autonomy of the state?
The premature dissolution is infringing the state autonomy because they are not getting the adequate time for the representation.
Then what
They are
will happen if a situation arises for the dismissal of the government or the dissolution of the legislature?
Still, Your Lordship, there will be a chance firstly for a by-election or a new frequent elections. But due to simultaneous elections, the particular state has to be under a president rule for that prolonged period until the next simultaneous election will come. Which shows that here, not only the state autonomy is infringed, but also the citizens' right to have an accountable representation of their own choice will be hindered. Because even under the president rule, the state will not be able to act according to their own rules and regulations, which is again infringing their autonomy. It is against the freedom of the state legislature. And as Article 174 talks about, that these states have their own timelines and they can make their own timelines regarding dissolution and the elections. List of 7 schedule, and secondly, any representation of the states in the parliament needs a ratification for at least one half of these states. Here, Your Lordship, there is no clear contention or a data which is talking about the ratification of these states in the regards to one nation, one election. There is no clear data for it. Apart from this, as I have mentioned, that Article 14 guarantees right to equality. Now, due to those disruptions caused, there is the potential chance that due to such huge change, there will be a lot of logistical, operational, manpower, security, everything will be needed. And failure in any of these will disfranchise the eligible voters if there will be failure in their voting systems, because it is taking part at a huge place.
Now, where is the question of a violation of Article 14 here?
Your Lordship, here the citizens have the right to equality and therefore they have the right to vote. Now, due to simultaneous elections,
This amendment is not taking away any of this right and, which is available under Article 14.
no, Your Lordship, it is. It is taken because
In what manner? In what manner?
simultaneous election talks about the elections of both state and
Whether the right to franchise, you mean to say that a particular right is there, on a given day, go and vote for electing your representative to the parliament.
yes, Your Lordship.
And you should be having another a right to go on another day to vote your member to the representative to the legislative assembly. No, the right to franchise will continue. You will be having the right to elect your representative to the Lok Sabha and also the representative to the state legislature.
I accept.
So there is
Your
no
Lordship.
question of any violation or taking away of the right.
No, Your Lordship, but this is a very huge change, which is a very huge change, and it will require a lot of things. And there is a potential chance that there can be failure in any of these things. It will be implemented after a very long time. There will be problems in security. There will be problems in manpower. There will be problem in logistical and operational power. There is a potential chance to it, which may curb the failure of the citizens to right to their vote. Their votes can be disfranchised, and it is against
See,
the right
once
to
you are
equality.
in this booth,
Yes, Your
no,
Lordship.
you will be getting this chance to vote for the parliament and vote for the legislative assembly.
Your Lordship.
And where is the question of a violation of Article 14?
Your Lordship, firstly, what I mentioned is there is the failure. Secondly, it is also an arbitrary power. The state is using an arbitrary power because, as I mentioned, that one nation, one election.
State is using arbitrary.
Union is using its arbitrary power. As I mentioned that here there is one nation, one election is not the only solution to curb down the expenditure. Through this one nation, one election, they are trying to impose one nation, one election, treating unequal entities as equal, as the states are undermined in the diversity of governance needs across the state. The council humbly submits that the independence of state legislature is totally rooted within the idea that they should make decisions in the best local issues. But due to one nation, one election, when the elections will be held simultaneously, the citizens may not be able to vote for the correct candidate in both they may end up voting the national parties for their state elections also, because this is proved under the IDFC Institute, which talks about that whenever there has been a simultaneous election, there is a 77% of chance that the people will vote for the same party. They may not be able to make or distinguish between the one which is good for the state and which is good for the national issue. One more thing, Your Lordship, one nation, one election is only talking...
So the chance for voting for any particular party, political party,
Yes, Your Lordship.
can that be a ground for challenging an constitutional amendment?
Yes, Your Lordship, it is because it is also the right of the citizens to have an accountable
See, nobody
government
is
for
interfering
them.
with the right. Absolute right of that person. It's an absolute right. It is for him to decide who should be my representative, according to me, to the parliament and to the legislature. That will continue to be there. Despite this amendment, even if it is upheld, that will continue to be there.
No, Your Lordship, one thing, that one nation, one election is only talking about how the simultaneous election will be elected. There is nowhere the contention that how will the
You are doubting
expenditures
the intelligence of the voter.
No, Your Lordship, I'm not doubting anybody, but I'm just talking that the one nation, one election have only talked about how will it be implemented and how will it go. There is no contention
See, he
that
is there
how...
in the polling booth, knowing that, yes, I am here to elect my representative to the parliament and then to the representative to my legislature, our state legislature. So that intelligence is there. You cannot say that no, he will not be having that much intelligence.
No, Your Lordship, there are still many states like the northeastern states which have different cultural diversities. There are states in the south which are having their regional
Then
representation.
move on to the next one. Any other good points?
Your Lordship, even if I talk about Article 21, as I said, that whenever there is a frequent election, even in case of emergency or if a CM resigns, there is a chance that they can have a frequent election or by-elections. But due to the simultaneous election, the state has to be under a president rule for that particular time, which will hinder the citizens to have their accountable representation according to their
Tell
own
us
choice.
then what is Article 21?
Article 21 talks about right to life and liberty.
In what manner it will affect?
Article 21 also talks about free and fair election. as it contains the right to life and liberty, it also contains all the democratic rights. And here, if the state will come under the president rule, the citizens will not have a free chance to have a free and fair election. They'll not be able to make an accountable government for themselves. They have to wait for a prolonged period for the next simultaneous election, which is hindering their rights, Your Lordship. They'll not have accountable representation for it. Apart from that, Your Lordship, I would like to contend that also in the case of G.D. Karkare versus T.L. Shevde, the Supreme Court clearly upheld that there is a need for free and fair elections, emphasizing that electoral processes must be impartial and conducted without arbitrary interference by any external authority, including the central government. The Election Commission's independence is crucial to ensure that the state and regional political dynamics are manipulated to favor the particular political interest. The case clearly interprets that the regional parties also have the right to contest and participate in elections. Your Lordship, here in the Chronica, there are still states in the northeastern part, there are still states in the south part who are more influenced by the regional parties. The council?
Conclude it.
The council seeks permission to just conclude the issue 4.
In 1 minute, please.
Yes, Your Lordship. Issue 4 talks about whether one nation, one election restricts the right of citizens to have an accountable government, minimizing the frequency of elections. Firstly, as I mentioned, that the citizens will lose their right to accountable government. Secondly, one nation, one election will also impact the voter behavior. As I mentioned before, that one nation, one election is not the only requirement of the frequent elections. It is not a need. It is just, whereas it is only an election manifesto which is influencing the citizens to make wrong choices, which is violating Article 19(1)(a), which protects the citizens to make informed choices. And as I've mentioned in the report, that there is a proof that these 77% of citizens have voted whenever there has been a simultaneous election, which shows that the citizens may be misled through the dominance of one nation, one election, and through the dominance of the national parties. Coming on to the part of Article 21, as I mentioned, that in the cases of emergency,
That 1 minute is over.
I'll complete the prayer.
It is standard time, it is not stretchable time.
Yes, Your Lordship. But with your permission, if allowed, I'll conclude with the prayer.
Please, in 1 minute.
Much obliged, Your Lordship. The Council humbly prays that, wherefore the lights in the facts presented and issues raised, the Council humbly prays that declared the present petition is totally maintainable and it is admitted before the Honorable Court. Secondly, to declare that the one nation, one election policy as unconstitutional as it strike down the policy and violates Article 14, 19 and 21 of the Crontican Constitution. Third, the court may also strike down one nation, one election policy which violates the fundamental rights of the citizens and undermines the free and fair election of the state autonomy, and pass any other order that this Honorable Supreme Court of Chronica deems fit.
Thank you.
Much obliged.
SMP 04 respond.
Greetings to the Honorable Bench. Am I audible, Your Lordship?
Yes.
Greetings to the Honorable Bench. May it please this Honorable Court, as this is counsel appearing on behalf of the respondents in the matter between people for constitutional ethos, hereinafter referred to as PCE in short.
Could you speak to this mic?
Sincere apologies, Your Lordship.
Something is wrong with that. Please.
Humbly submitted before this Honorable. It is humbly submitted before this Honorable Court.
You are even otherwise audible. That's another thing. Better. The others, they should also hear. Please ask somebody to correct. What?
Hello.
Yes.
Greetings to the Honorable Bench. May it please this Honorable Court, as this is counsel appearing on behalf of the respondents in the matter between People for Constitutional Ethos, hereinafter referred to as PCE in short, and others versus the Union of Frontica. If your lordships are well versed with the factual metrics of the case, the counsel seeks permission to move on to the issues at hand. Much obliged to your lordship. So the first issue is pertaining to whether the present petition are maintainable, and the second issue is pertaining to whether the acts passed by the Parliament.
Don't take that there is an issue. The court never put any question. Are you having a case that it is not maintainable? And if so, why?
Indeed, my lords. So it is humbly submitted before this Honorable Court that the present petition is not maintainable as it does not meet up with the jurisdictional requirements and it does not meet up with the legal threshold as enumerated under Article 131 of the Constitution of Karnataka, Your Lordship, as there has to be a violation for an enforceable legal right, Your Lordship, and also in order
Is it a legal right or a fundamental right? Article 32?
My lords,
is there any difference between legal right and fundamental right?
Indeed, my lords. But as I've stated before, it is Article 131, Your Lordship, in order to clarify this bench.
So firstly, you are addressing that Article 131. Then continue.
Read with Article 32, Your Lordship. And also, in order to invoke the jurisdiction under Article 32, there has to be an exclusive violation of fundamental rights, Your Lordship. And this petition must be dismissed at the very threshold, and this argument shall be substantiated into 3 points of determination as follows, Your Lordship. So the first point of determination would be this present petition does not satisfy any requirements under the Article 131 of the Constitution of Karnataka, Your Lordship. As the Article 131 requires a dispute involving an enforceable legal right, Your Lordship. As it is limited to disputes between the states and union concerning the existence of an extent of a legal right, and it does not extend to mere ideological disagreements or policy disagreements. As it was considered in the case of Rajasthan versus Union of India, the Supreme Court, through Justice Chandrachud, categorically held that the mere discrepancies or any wrangles between the governments do not fall under the ambit and also shall not fall as a ground to invoke the jurisdiction under the Article 131, Your Lordship. And also, it was also reiterated in the case of State of Karnataka versus Union of India, and it is meant to resolve, the rationale behind the judgment is that it is meant to resolve.
State of Karnataka, are you referring to 58, AR 1958?
No, Your Lordship.
Then?
1977, Your Lordship.
77?
Yes, Your Lordship. I would like to draw your attention to paragraph number 1.1.1 of the...
No, you did not cite this, give the citation. You only said State of Karnataka. 77. Oh, please.
1977 AR 1361.
What is the ratio? I only wanted to test whether they have gone through that.
Your Lordship.
Overhead?
Your
So
Lordship.
the intention, you know.
Your
Are you
Lordship.
thinking that we never had an occasion to go through these judgments?
Your Lordship, I would like to draw your
You are
attention.
presenting well, but at the same time, we want to know.
Indeed, Your Lordship, in order to enlighten this honorable bench, the council would like to draw your attention to flag 6 of the Moot compendium, Your Lordship, in order to peruse the entire judgment at hand, Your Lordship. Please, peruse, Your Lordship. And also a specific person for the judgment. Quote, it is meant to resolve legal conflicts and not to serve as a forum for abstract constitutional debates. Unquote, Your Lordship. And moving on to the second point of determination is that Article 131 does not permit a challenge to the constitutionality of the central legislation, Your Lordship. It is furthermore submitted, although in the case of State of Jharkhand versus Bihar of 2024, the Supreme Court took a broader perspective of Article 131.
Are you claiming an immunity for this legislation by the parliament? Is there any absolute immunity? Are you saying that it is beyond judicial review?
No, Your Lordship. But the council would want to make it clear to this honorable bench that in order to invoke the jurisdiction as enumerated under Article 131.
So it is amenable to judicial review.
Indeed, Your Lordship.
Therefore, on what ground? Why you are saying that it's not? This is not. This particular case is not maintainable. This amendment is beyond that. Why you are saying so?
My lords, in order to invoke the jurisdiction under Article 131 and 32 as contended before, there has to be an appropriate cause of action proving beyond reasonable doubt that there is a violation of one. In order to meet up with the Article 131, there has to be a violation of legal rights. And there has to be a violation of fundamental right, exclusively fundamental rights as enumerated under Article 31 in order to include, in order to invoke the jurisdiction of constitutional remedies as enumerated under Article 32, my lords. If your lordships are convinced with the arguments, the council seeks permission to proceed further. As reiterated before, the state of Jharkhand was the state of Bihar. As the Supreme Court has taken a broader view with respect to the Article 131, but at the same point of time, the state of Madhya Pradesh was the Union of India, since both the cases were decided by the coordinated benches, but the 2011 ruling in the case of state of Madhya Pradesh was the Union of India was not overruled by the case of state of Jharkhand versus state of Bihar. This is to enlighten this honorable bench that this overrules the decision that the state of Madhya Pradesh, it is a well-settled law that Article 131 cannot be used to challenge the constitutional validity of a central legislation, my lords. And also, your lordship, the council would like to move on to the second issue. If
See, why we are putting this question, every time you are referring to certain decision in the AIR or SEC, why you are saying that are you saying that it is having any presidential right, or it can be, the ratio of the decision can be looked into by this court?
It is a ratio that the courts can refer on to.
Otherwise, it seems that you are also in a dilemma.
No,
you are referring about the amendment brought by the Parliament of not India. And therefore, the other decision, if the ratio of that decision is applicable, please.
But your lordship, I would like to draw your attention to the very last line of the Moot proposition itself, your lordship. It was very clearly stated that
therefore, imbibe that and then argue.
That the laws in Chronica are pari materia to the laws in India, and also the legislative framework in the Chronica.
Therefore, that decision laid down, the ratio laid down in that decision is applicable in this case. That is not the manner in which you are arguing. That is why we are putting this case.
The council seeks permission to address the second issue at hand, your lordship. Much obliged, your lordship. The second issue at hand is whether the acts passed by the parliament for one nation, one election are constitutionally valid, your lordship. It is humbly submitted before this honorable court that the impugned legislation, which is the 29th Amendment of the Amendment Act of the Constitution, and the Election Synchronization Act of 2024 are constitutionally valid as they satisfy the established judicial test for constitutional validity, your lordship. And also, these provisions do serve a legitimate nation's interest, and these are proportional to their objectives as such, your lordship. And this argument shall be substantiated into 5 points of determination as follows, your lordship. So the first point of determination being, the one nation, one election framework is a proportionate and necessary measure to address the electoral inconsistencies, your lordship. So,
to address the electoral inconsistency, what is that?
Which will be addressed in the forthcoming arguments, your lordship. Frequent elections have led political parties in power to prioritize populist measures over the national.
You used a better of this expression, electoral inconsistency.
Indeed, your lordship.
What do you mean by that?
If we take it in a practical sense, my lords, the political parties, in an attempt to win over the voters, especially economically weaker vulnerable population, tend to promise and implement individual benefits such as loan waivers, free housing, food subsidies.
Are you saving out freebies?
In a way, indeed, my lords. That was also one of the inconsistencies as addressed by the judiciary earlier, your lordship.
Yes.
Moving further, and free electricity rather than focusing on the broad-based development policies, your lordship. It was held in the case of S. Subramanian Balaji versus the government of Tamil Nadu and others. It was clearly held out that all these practices, the aforementioned practices, do undermine the free and fair elections, and reducing the frequency of election would substantially curb all these tendencies at hand, your lordship. And continuous election cycles do create a pertinent risk of misuse, which can be effectively mitigated through a synchronized electoral system, your lordship. And moving further, a voter turnout is a crucial indicator for representative democracy, as it reflects both political engagement and civic responsibility, your lordship. And also, I would like to enlighten this honorable bench with the Supreme Court's ruling in Tamil Nadu Education Department Ministerial General Subordinate Services Authority Association and others versus State of Tamil Nadu and others. I beg your lordship I would like to draw your attention to flag 7 of the Moot compendium, your lordship, to peruse the entire judgment as such, your lordship. And as the court observed that once a policy is found to be rational, isolated instances or minor discrepancies or minor hardships cannot justify its invalidation, my lords. And moving further, therefore, also in the case of Abu versus Union of India, the Kerala High Court held that neither Article 172 nor Article 174 of the Constitution mandates that the state legislation can only be dissolved after its first session. And also, in reference to that, I would like to enlighten this honorable bench with special reference number 1 of 2002 Gujarat Assembly election case, wherein the Supreme Court recognized once a legislative assembly is constituted, it may be dissolved at any stage, provided that constitutional procedures are being followed as such, my lords. And moving on to the second point of determination.
So you mean to say that there cannot be a guarantee that it would be permitted to continue till the expiry of the period? Or 5 years is the term?
Indeed, Your Lordship.
There cannot be a guarantee. Are you saying that?
There is a guarantee, Your Lordship. There are constitutional mandates and guarantees in compliance with the constitutional framework, Your Lordship.
So unless the other contingencies are arising, suppose if they are not arising, calling for dissolution, dismissal of the assembly or dismissal of the government, the elected government, it can continue. It can continue.
Indeed, my lords. It is the governor who will re-elect, even in the instances as contended by the my lords, as contended by the appellants.
That is what it is.
As contended by the petitioners, Your Lordship. Sincere apologies, Your Lordship. As contended by the petitioners, the council seeks permission to proceed further, Your Lordship.
There is no question of election of government, election of representatives. The elected representatives will, of course, the majority of any parliament, they will form the government.
Indeed, Your Lord.
That is why we said in the Bombay's case also, it is dismissal of the state government and the dissolution of the assembly. 6 state governments were dissolved in that case.
Certainly, my lords.
So
the second point of determination is that simultaneous elections align with international electoral practices globally, and several nations have successfully implemented simultaneous elections, reinforcing the legitimacy of the one nation, one election framework, Your Lordship. Countries such as, my lords, the council seeks permission to proceed further, my lords. The countries such as Brazil, Bolivia, Colombia, Costa Rica, Guatemala, and Sweden, and also Philippines also conduct synchronized elections to ensure the governance stability and to reduce the administrative costs and prevent electoral corruption, my lords. Although many of these countries do follow a presidential system, their adherence to a single electoral cycle underscores the benefits of simultaneous election in fostering the democratic efficiency, my lords. This brings us back to the third point of determination as such. One nation, one election is a constitutional restoration and not a violation of democratic principles, my lord. It is humbly submitted before this honorable court that the concept of simultaneous elections was the original framework as envisaged by the framers of the constitution, who are the forefathers of the constitution. And ranging from 1952 to 1967, elections to the Lok Sabha and the state legislative assemblies were conducted simultaneously, ensuring the stability in governance. However, this framework was disrupted due to the premature dissolution.
See, elsewhere it is synchronized. That is the election to the state assembly and to the parliament. Can that be a reason for bringing this kind of an amendment to the constitution?
But there were several discrepancies post-independence, Your Lordship. And also at this point, and also at the legislative intent to bring back the underlying concept.
Why you are saying that it is within the basic structure for a doctrine? It will not violate. It is not at all violating the basic doctrine structure.
Indeed, Your Lordship. It does not violate.
Why? Are you saying that it is not undemocratic?
It is democratic, my lords.
We are only asking. Don't be under the impression that we are saying anything. They said, that is why we are putting it to you. Their contention that it is undemocratic. Why you are saying that it is democratic? Of course, we put the question to them also.
The democratic values are being upheld, and also, in fact, this approach brings a broader scope to enforce their constitutional rights to as a right to vote, Your Lordship. In case, let us take a situation at hand. If a person who is disinterested with who has no interest with the election policies or any electoral manifestos pertaining to the state legislature or any legislative parties pertaining to the state legislature, but he has the or in case if he is lethargic towards the fact that he does not want to enforce his right to vote, Your Lordship, but in case if the simultaneous elections were held in force, there is a very high probability that while he is voting for under the local election, there is a very high possibility that he may also vote for the legislative assembly elections as well, Your Lordship.
Is it necessary? Whether his vote which he cast in the case of the parliament will be invalid if he does not cast his vote as regards the election to the state legislature? No. It is up to him to decide.
Indeed, Your Lordship, but also it is the duty of the Constitution.
Vice versa also. There is no such a provision. It is up to him to decide.
Indeed, Your Lordship, that is with respect to the personal interest and also the liberty of the person to vote and also to refrain to vote, Your Lordship. But it is the duty of the Constitution to enforce the democratic principles by several machineries and like one nation, one election as such, Your Lordship. If Your Lordship is satisfied, the Council seeks permission to move forward. May I?
We will simply smile. Because how can we refrain from smiling when all throughout you are smiling? Please.
So moving on to the last point of determination is that the central government's power to dissolve a state government under Article 366, as this issue was taken into cognizance in the 170th Law Commission report of 1999, which supports the contention that the central government's powers to dissolve a state government under Article 356, Your Lordship. And also, I would like to draw your attention to the second flag of the Moot compendium as such in order to peruse the entire document of the 170th Law Commission report as supplied by the other commission reports as well, Your Lordship. And also, the misuse of the provision was curbed in the S.R. Bommai versus Union of India, where the Supreme Court ruled that the dissolution under Article 356 must be based on objective material demonstrating the failure of constitutional machinery. However, the court did not prohibit such dissolution, but emphasized that, that it must be judicially reviewable. And furthermore, reiterating the same concept that the judicial review is still a part of the basic structure doctrine, my lords. And also the last limb of the argument pertaining to the second issue is that...
Now you may have to conclude within 1 minute.
One more minute, my lord, with your due permission, my lord, please. So, in order to consider the last limb of the argument, which is the constitutional validity of aligning elections, my lords, the Supreme Court in Kuldeep Nair versus Union of India, I would like to draw your attention to flag number 5 of the Moot compendium to peruse the entire document as such, my lords, upheld that the changes in...
Is it Kuldeep Nair?
Yes, my lords. Kuldeep Nair versus Union of India, 2006, writ petition civil number 217 of 2004, my lords. The council seeks permission to proceed further, my lords. Upheld that the changes in electoral procedures are permissible as long as they do not violate the constitutional principles. And the one nation, one election framework does not remove elections or disfranchise the voters, my lords. And moving on to the third issue at hand, if your lordship may permit. In brief and in short, my lords.
See, short, you are saying that it is short, but then in effect it is not. You want to say, what's your prayer ultimately?
With your due permission.
For a respondent, it is very easy. You need only to say that dismiss the petition.
Indeed,
What more you want to say?
Indeed, my lords.
That you can say in one sentence.
With your due permission, my lord, the council on behalf of the respondents would like to contend further to place appropriate reasonings, my lords.
Most probably, they will add one more sentence with a cost.
So with that being said, as the court is concerned, the council seeks permission to conclude the arguments as such, if with your convenience, my lords. Considering the time constraints as well, my lords. So, the council seeks permission to conclude the arguments as well, my lords. With the aforementioned...
We gave time to 1 minute to everyone, so 1 minute you will have to say.
With the aforementioned arguments placed, considering the time constraints, the council on behalf of the respondent would like to conclude by stating that the facts are undisputed, the political policies are undisputed, and both the impugned provisions are undisputed at the present scenario and shall also be undisputed in the future days to come. And with that being said, the council seeks permission to move on to the prayer, my lords. Much obliged to your lordship. Wherefore, in the facts of the facts stated, issues raised, and arguments advanced, and authorities cited, it is humbly requested that the Honorable Court may be pleased to adjudge and declare that the present petition is not maintainable under the Article 131 and the 32 of the read with Article 32 of the Crontia Constitution, and the Act passed by the Parliament for one nation, one election were constitutionally valid, and the one nation, one election does not infringe upon the independence of the state legislature by enforcing uniformity in an election cycle, and the one nation, one election promotes the rights of the citizen to have an accountable government, minimizing the frequency of election, my lords, and any other order as it deems fit in the interest of equity, justice, and good conscience. For this act of kindness, the petitioner shall be duty bound forever. Respectively submitted by the council on behalf of the respondents. It is indeed a pleasure to place the arguments before this honorable bench, my lords.
You are for the respondent?
Indeed, my lords.
Then, please take your prayers. At page 26,
Yes, my lords.
read silently the second prayer.
The acts passed by the Parliament for one nation, one election were constitutionally valid.
Were constitutionally invalid.
Were valid, my lords. Bench clerks, please. My lords, there could have been a clerical error in case of any technical error on behalf of the submission, but based on the
See, in real life, you may have to face these kind of situations. That is why we really wanted to know how you will face this.
Sincere apologies, my lords.
You did this, but usually the regular lawyers, the lawyer said, put everything, put the entire blame on the clerk, the poor clerk. And whenever there is any delay, and if it is a long delay, nowadays you go to another ground. Put the entire blame on? No, COVID.
Sincere
No,
apologies.
these are the two, COVID and the poor clerks.
Sincere apologies, my lords. There was a technical error.
Here it is.
My lords?
Declare that they were constitutionally invalid.
There could have been a clerical or a technical error, my lords. Sincere apologies.
Not the apology. You really wanted to say, I want to file an application for correction. That we expected from you. That is advocacy.
First year, my lords.
And then you can say that, yes, I will put in appropriate application for amending the prior. Yes, in rebuttal you want to.
The council seeks permission to rebut the learned counsel. Your lordship, the learned counsel has mentioned all the contentions, but nowhere they have given the justification of Article 1, which states that union of states into a unitary state. They have stated that it is not in hindrance with the federalism, but then where is the justification of the amendment made like of unitary state? It clearly states that there is a dominance of the central government, there is a dominance of the union, there is no justification given by the learned counsel about the amendment made under Article 1. Second thing, on page number 17, in the case of Kuldeep Nair versus Union of India, they have mentioned that only when the constitutional principles are not hindered and when the citizens are not disfranchised from their votes and do not infringe upon their democratic rights, then the dissolution of the assemblies can take place. But in the present case, there is a contention where the democratic rights like free and fair elections are hindered, the accountable representation are hindered, there is a potential chance that the voters may be disfranchised from the eligible voting. Lastly, your lordship, on page number, on the paragraph 1.1.2, they stated that the Sinchal Pradesh has not demonstrated the existence of any enforceable legal right. It is clearly mentioned that Sinchal Pradesh has talked about the distribution of power, which talks about federalism. They have existed in the enforceable right of federalism. And also in the next 1.2.3, the case of state of Karnataka versus Union of India, also they have stated that states must demonstrate the denial of the legally enforceable right. That means they also agree that if there will be a legally enforceable right, then it is unconstitutional. And here the right, the preamble, the main essence of the Chronica, the federalism, apart from that, the fundamental rights, all of these legal rights are being hindered. And as I already mentioned that they have not given any justification of Article 1 amendment, then how are they even stating that there is no legally enforceable right? That's all, Your Lordship.
Yes.
My lords, am I audible? With your due permission, my lords, in order to answer to the first question, that in order to exercise full federalism, the concept of federalism in a full-fledged way is practically impossible at the situation at hand in the Union of Chronica. It can be applied in a completely developed country like United States of America, but it is practically impossible with the state at hand. That's why we had quasi-federal structure. And now, there has to be, in order to meet the ends of interest of the nation, there has to be somewhat amount of centralization in order to promote these democratic values and to uphold the principles as enumerated also in the DPSP, my lords. And to answer the questions 2 and 3, and these submissions were never a part of the oral argument submitted, and the oral arguments submitted on behalf of the respondents were in compliance with the submission with respect to the original compendium at hand. And also,
you actually wanted to say original arguments or oral arguments?
Oral arguments. Sincere apologies, Your Lordship.
Yes.
Oral arguments.
They have their written arguments.
The council seeks permission
They refer to relevant paragraphs also.
The council requests the opposite council to repeat the second and the third question as such in order to answer it, my lords. One last, if your lordship permits.
No, why we said is they refer to particular paragraphs. Yes, anyway. Continue with that. Continue to rebut.
As mentioned in the paragraph number 1.1.2, it has been clearly submitted in the present case that the state of Sinchal Pradesh has not demonstrated the existence of any enforceable legal right, my lords. Obviously, my lords, federalism, as contended by the petitioners, is not a mere constitutional right. It is a basic structure of the constitution, but not a mere constitutional rights as enumerated under fundamental rights as enumerated under part 3 of the constitution of Krontika, your lordship. And council seeks permission for the third issue as well. Third question as well, your lordship. To address
which question? Which is that question?
The third question, my lords. It was not audible as such.
If you want to say anything further, we will not say whether it is first question, second or third. In 1 minute, complete it. Completed. Yes. Thank you. We permitted you to take 1 minute. You never want to.
Sincere apologies, my lords. The question, my lords, the council seeks pardon to the council.
So you want the other side to put that question and then you to answer, or you want us to put a question?
No, your lords. No, my lords. In order to clarify the pertaining to the third question alone, your lordship. If your lordship may permit, the council seeks the opposite council to.
You are saying that clarity, that word, you use the word clarity. What is the vagueness? If any vagueness in the petition, definitely the respondent should take advantage of that.
No, my lords. With respect to the rebuttals made, the council wants to the council wants my learned friend to repeat the third question as mentioned in the rebuttals, my lords. With your due permission, that was
you could not follow what the third question. It's not question. Understand, in any court, the parties they are not permitted to question. They can advance the arguments. And the privilege to put the question is always with the court. There is no argument between the council. You are only addressing the court. So if you could not follow any particular argument, you can say that of that particular argument I could not follow. That we can understand. That should be the way in which. Yes. Thank you.
Honorable judges, all the dignitaries and students present in the auditorium, with the permission of honorable bench, I declare that the 3 rounds which were designated for final round of this moot court competition ends here. With the permission of bench, we take a break of 10 minutes before valedictory session starts. I request honorable judges to please, I request all the escorts to please accommodate honorable judges in the green room. Yes. Obliged, your lordships. Justice is the foundation upon which civilization stands, and advocacy is the voice that upholds it. Moot court competitions are not just about arguments. They are about learning, evolving, and refining the very art of persuasion and legal reasoning. A very warm good afternoon to one and all present here. I, Aditi Ankush, the convener of Moot Court Association, feel immensely privileged to welcome you all to this valedictory session of our esteemed Silver Jubilee Moot Court Competition 2025. Organized by Marathwada Legal and General Education Societies, Manikchand Pahade Law College, Chhatrapati Sambhajinagar. This occasion marks not just a 25th edition of our prestigious competition, but also a celebration of spirit of mooting, legal intellect, and pursuit of justice. We are truly honored to have among us distinguished jurists who not only grace this occasion with their esteemed presence, but have also judged the final round of this competition. Their keen legal insights, vast experience, and meticulous evaluation have made this competition a truly enriching experience for all of us. We have with us chief guest of today's program, Honorable Shri Justice C.T. Ravikumar sir, former Judge, Supreme Court of India. And we also have with us guest of honor, Honorable Shri Justice Kailash Chandiwal sir, former Judge, High Court of Judicature of Bombay, Bench at Aurangabad. We extend our deepest gratitude to both our esteemed guests for taking their time to judge the final round and for sharing their profound knowledge, ensuring that this moot court competition remains a true test of legal skills and advocacy. We are truly honored to have among us other distinguished dignitaries whose presence today enriches this event. Advocate Dr. Kalpalata Patil Bharaswadkar ma'am, President of Marathwada Legal and General Education Society, Chhatrapati Sambhajinagar. Dr. C.M. Rao sir, Principal, Manikchand Pahade Law College. Mr. Professor Shri Krishnan More sir, Vice Principal. And Dr. Aparna Kotapalle ma'am, IQAC Coordinator. Along with them, I extend a very warm welcome to all the distinguished guests, member of Marathwada Legal and General Education Society, esteemed judges, advocates, respected faculty members, participants, and students who have gathered here today. Your presence adds immense value to this occasion. Light symbolizes knowledge, wisdom, and enlightenment. As we light this lamp today, we invoke the spirit of justice and learning. I now request our esteemed dignitaries on the dais to please come forward for garlanding of the portrait and lightening of the lamp. we light this lamp today, which symbolizes the knowledge, wisdom, and enlightenment in all of us. Thank you, respected dignitaries. Thank you, Lordships. The preamble is not just an introduction to our constitution. It is a very soul of our democracy. As our celebrated tradition of this college suggests, we start each and every program with recitation of preamble to constitution. I request everyone present in this hall to please raise for recitation of preamble. I request everyone to please repeat after me. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic and political, liberty of thoughts, expression, belief, faith and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Jai Hind. I request everyone to please settle down. As we move forward, true wisdom lies in sharing knowledge and experiences. And today, we have among us a very distinguished guest who has shaped the legal landscape of our country. I now invite Mr. Venkatesh Gaikwad to introduce our chief guest, Honorable Shri Justice C.T. Ravikumar sir, former Judge, Supreme Court of India.
Good morning, esteemed dignitaries, honorable judges, respected faculty members, participants, and dear students. It is my profound honor to introduce His Lordship's retired Supreme Court Justice C.T. Ravikumar, who has graciously joined us for the final round of Silver Jubilee Moot Court Competition 2025, organized by Marathwada Legal and General Education Society's Manikchand Pahade Law College, Chhatrapati Sambhajinagar. His Lordship's journey in law is one of dedication, perseverance, and service to justice. He was born in Pirmade, Kerala. His Lordship was influenced early on by the judicial system, with his father serving as bench clerk in Judicial First Class Magistrate Court, Changanseri. Despite an initial academic pursuit in zoology at Bishop Moore College from Mavilkera, his Lordship's passion for law led him to obtain an LLB degree from Government Law College, Kozhikode. Enrolling as an advocate in 1986, his Lordship began legal practice in Mavilkera before shifting to Kerala High Court in Ernakulam. Following the advice of Chief Justice of India, K.G. Balakrishnan. Over the years, his Lordship built a stellar reputation in civil, criminal, labor, and service law. His Lordship served as government pleader from 1996 to 2001 and was later appointed as senior government pleader in 2006. In January 2009, his Lordship was appointed as additional judge of Kerala High Court and was made permanent judge in December 2010. His Lordship's contributions extended beyond the courtroom, serving as the President of Kerala Judicial Academy and as Executive Chairman of Kerala State Legal Services Authority, fostering legal awareness and access to justice. In August 2021, his Lordship was elevated to Supreme Court of India, becoming the 15th judge from Kerala to hold this prestigious position. Throughout a distinguished tenure, his Lordship's authored 99 judgments and been a part of 373 benches, making a profound impact on Indian jurisprudence. A strong advocate of judicial prudence and discipline, his Lordship has contributed immensely to legal landscape, particularly in criminal, property, and family law matters. His Lordship superannuated from the Supreme Court on January 3, 2025 after a tenure of 4 years, and it is our duty to not only reflect on a career of remarkable legal contributions, but also on a legacy of wisdom, fairness, and dedication to justice. It is indeed a privilege to have His Lordship with us today. Thank you.
We are truly honored for your presence here, sir. I now request Dr. Kalpalata Patil Bharaswadkar, ma'am, to please felicitate our chief guest, Honorable Shri Justice C.T. Ravi Kumar, sir, with shawl, shrifar, memento, and token of gratitude. Thank you, sir. Thank you, ma'am. We are also very privileged to have with us Mrs. Saira Ravi Kumar, ma'am. I request ma'am to please come on the stage. I again request Dr. Kalpalata Patil Bharaswadkar, ma'am, to please felicitate ma'am. Thank you, ma'am. I now invite Ms. Omisha Priya to introduce our guest of honor, Honorable Sri Justice Kailash Chandiwal, sir, former Judge, High Court of Judicature of Bombay, bench at Aurangabad.
Thank you, Aditi. A very warm good afternoon to respected dignitaries, learned advocates, esteemed faculty members, dear guests, participants, and fellow students. Today, we are gathered here for the valedictory ceremony of Silver Jubilee National Moot Court Competition organized by Manikchand Pahare Law College. I feel immense pleasure and profound honor to introduce to you our distinguished guest of honor for this occasion, Honorable Justice Shri K.U. Chandiwal, sir. His Lordship was born on 7th of May, 1952 at Aurangabad, and I am jubilant to state that he is an alumni of MP Law College who completed his LLB degree in 1976. After that, he joined District Bar Association in September 1976 itself and started his advocacy career in civil, criminal, and revenue matters. His Lordship also worked as a legal advisor to 6 nationalized banks, including several civil suits and appeals of far-reaching importance. On 5th February 1993, his Lordship was selected as a judge at Bombay City Civil and Session Court, and for more than 5 years, he worked as a special guest under NDPS Act and decided matters involving international traffickers. On 14th April 2008, his lordship was elevated as a judge of Bombay High Court, having sitting at 3 of the places at Bombay, Nagpur and Aurangabad, where he handled versatile and paramount matters. With this significant contribution in the judicial arena, his lordship got his superannuation in the year 2014. Moreover, his lordship continued to contribute to legal landscape through many unwavering commitments beyond the courtroom. Even after his superannuation, his lordship was appointed as the head of several committees like chairperson of Judicial Commission by Government of Maharashtra under the Commissions of Inquiry, and additionally he was holding charge as the chairperson of Appellate Tribunal under Real Estate Regulatory Authority for 1 year. His lordship was the president of Maharashtra Revenue Tribunal, Mumbai till 2023. Hence, his lordship's presence not only adds great honor to this event, but also serves as an inspiration to all aspiring lawyers present here. Thank you so much. Have a great day ahead. Over to you, Aditi.
Thank you so much. We are truly, truly grateful for your presence, your lordships. I now request Dr. C.M. Rao sir, Principal of Manikchand Pahade Law College, to please felicitate Honorable Shri Justice Kailash Chandiwal sir with shawl, Shrifar, memento and token of gratitude from all of us. Thank you, sir. I now request Dr. Aparna Kotapalle ma'am, IQAC coordinator, to please felicitate Advocate Dr. Kalpalata Patil Bharaswadkar ma'am, President of Marathwada Legal and General Education Society. Please, ma'am. Thank you, ma'am. A great initiative is never a solo effort. It thrives on contribution of dedicated individuals. I request our esteemed guest to please felicitate the luminaries whose efforts have made this event a grand success. Firstly, I call upon respected Advocate Rajendra Deshmukh sir, Senior Counsel at High Court of Bombay Bench at Aurangabad, and request the honorable guest to please felicitate sir with token of gratitude and memento. We are truly grateful for sir's immense contribution for this competition. In addition to the constant support which sir has been providing for last many years, This year, sir has also provided us with extra effort, extra support to our hands, and we are very, very grateful for that, sir. Thank you. I now call upon respected Advocate Avinash Deshmukh, sir, on the stage and request all the dignitaries on the stage to please felicitate him.
We are local, sir.
I am also local. I am also.
Now onwards, you are also local.
We are very, very grateful for all the support and guidance. Thank you. Thank you, sir. I now call upon co-convener of Moot Court Association, Mr. Jay Gowde, to take over.
Thank you, Aditi. Every great argument begins with a great problem. A moot court problem is the foundation upon which advocacy is built. Today, we take this moment to honor those who crafted this year's challenging moot problem. I request our esteemed guests to felicitate our moot problem setters. Firstly, I invite Advocate Shahrukh Shah, whose problem was selected for preliminary and semi-final round, and I request our guests to felicitate him. Now I invite Mohit Patan, whose problem was selected for the final round of competition, and I request our guests to felicitate him. Thank you, honorable guests. To understand the legacy and the contribution of our institution, I invite Dr. C.M. Rao, sir, the principal of Manikchand Pahade Law College, to give a brief overview of our college.
Respected honorable judges, Justice C.T. Ravikumar, Justice Chandi Valsab, respected members of the MLG Society, honorable guests, and participants from all over India, and my dear students and my colleagues. It gives me immense pleasure to be here to say a few words about this institution. In 1956, this was the college which was started with the avowed object of spreading legal education for the have-nots. This is the only law college in entire India which is the lowest fees in India continuously for last 5 years. In these particular 2015 to 2025, we won 29 laurels from various surveys conducted by India Today, Careers 360, The Week, IAF. So there are several magazines who are conducting surveys on their own with the supporting documents which are supplied by our faculty members for the support of their claims. So we, the management, staff and students together, running several platforms for the development of enrichment of students in different beyond books. One such among them is the Moot Court, which you envisaged today. The second one is PowerPoint presentation competition. The third one is Electoral. Apart from these particular things, social research, for that the Avishkar Research Club, green initiatives, mentoring skills, ragging, not ragging by us, ragging redressal programs from students, and innovation that is going to be made, whatever the judgments that are given, legislation that are brought by the government time to time by the apex courts and high courts. There is a program that is conducted. The students will present their skills. It started with 6 students. Now it is 56 students who are participating every year. Every year there is a program where they are going to exhibit their skills beyond books. This is the particular institution which with only one object, betterment in education excellence. We are not bothered for earning money. Whatever the facilities that are provided, only with one mindset of our management staff is only how to deliver best quality of legal education in this particular region. This is not because of management and staff, it is because of our students who participate in all activities with their committedness and also dedication towards the particular work they are interested in the process of the platform that are provided to them from time to time. In the last 1 year, our students won second prize in advocacy skills in Rajasthan Law University, State Law University, second prize. Recently in ADR in Trivandrum, they won second prize in Moot. Recently they won first prize in advocacy skills in Nagpur University. So this is not because of the faculty or any member of the management. It is because of the students who have dedicated themselves, excelling themselves in the particular platform that are provided by us. In sports also, nobody is inferior because an advocate must have fitness. So there are 41 activities that are committed in the university for every year. Today our faculty member who is going to hold the particular Krida Mahotsav in State Krida Mahotsav in Chandrapur, our faculty member is nominated by Rajyapal. It is a pride moment for us. Whatever the thing that we are doing, appreciated not only by the people coming here, and also the people who are watching us, also giving an opportunity for all of us to excel ourselves in better education for the students. And it is not only that the Bar Council, the other members of the judiciary, right from official court to higher court, always support us in any activity, whether field visit is the only college where our students are taken to field visit, as you envisaged in the particular video, taken to agriculture fields, measurements, taking to industry to know about awareness about the pollution of water, pollution of air, pollution of noise. All these things are going to be practically known to students because of the efforts that are taken by our staff members. Though number is less because of the policies of the government, but we are doing tremendous work for the betterment of the students with the support of management. I would like to say one thing in this particular institution. This is the only institution in India where management is working only for the better education, not for earning money. So nowhere in India we find this type of management. Everywhere the greedy and needy people are working for the betterment of the education, how to make the earning of money. But this is the only management in India which is only working for betterment of the education in this backward region of Marathwada. So I once again thank Justice Ravi Kumar. Just a phone call through which he accepted our invitation. I also thank Saira Ravi Kumar madam for accompanying us for this particular wonderful event of Silver Jubilee, which is a refreshing memory forever for the management, staff and student, also for the participant. Thank you one and all.
Thank you, sir, for your constant guidance and support. To highlight the importance and scale of this competition, I now invite Dr. Anju Singh ma'am, the coordinator of Moot Court Association, to brief us about this year's competition.
Thank you, Jay. Chief guest, Honorable Sri Justice C.T. Ravi Kumar, former Judge of Supreme Court of India, New Delhi. Guest of honor, Honorable Sri Justice Kailash Chandiwal, former Judge, High Court of Judicature of Bombay, Bench and Aurangabad. Advocate Dr. Kalpata Patil Bharaswadkar, President and President of our Marathwada Legal and General Education Society. Vice President, Advocate Senior Counsel Rajendra Deshmukh sir. Secretary, Advocate D.S. Kulkarni sir. Joint Secretary, Advocate Narendra Deshpande sir. All honorable members of the society, invitees, distinguished guests, faculty members, participants, and dear students. A warm good afternoon to all of you. On behalf of Manikchand Pahade Law College, I welcome you all in the prize distribution function. And at this moment, I feel privileged to brief about the moot court competitions which happened yesterday and today. So every year, our college organizes national moot court competitions. This year, we have organized Silver Jubilee Moot Court competition. Why Silver Jubilee? Because this is the 25th year which we have successfully organized national moot court competitions. Earlier, the college used to organize state-level moot court competitions. And now, in this way, we have completed total 50 years of moot court competition in our institutions. This happened because always we get motivation and encouragement from our management members, and they give more importance on the moot court activities. Now, regarding the competitions, this year, 25 law colleges from different parts or different states, such as Maharashtra, Karnataka, Tamil Nadu, Andhra Pradesh, Assam, Odisha, Haryana, have participated in this function, and even the Goa also. So I thank all the participants who have come from all the colleges, and you have given your wonderful performance in this institution, and we will be eagerly waiting for your feedback so that I can improve. We can improve in our upcoming moot court competitions. So how the competition takes place, the first stage is we invite moot propositions. And the uniqueness of the college is what? The invitation for the framing of moot problem is sent to various law colleges where the faculty, students, and the advocates are requested to frame the moot court problems. So once we receive the moot problems which are framed by them, so we are having panel of 3 judges. Me, myself, I do the coding of the moot problems, and it is sent to the panel of judges constituting the retired judge and 2 senior counsels of High Court. Accordingly, they select 2 moot propositions, one for preliminary and semi-final round, and other for final round of the competitions. And once this task is over, now the task comes to prepare the brochures. So I'm very glad to inform you that this time, student Venkatesh Gaikwad, BA LLB second year, has made the brochure, so I appreciate his effort. So after the brochure is made, with the moot propositions, with the rules, regulations, registration form, it is released. It is released on various social media. It is mailed to various reputed law colleges, traditional law colleges, and moreover, it is also posted on Law Octopus. And accordingly, we receive the registrations from all over India, and it happened that many students have participants, and at the last moment, I have to close the link because it becomes very difficult to manage so many participants. So again, we are thankful all to the participants, and I hope that next year also you are going to come and your institute is going to participate. Now, the unique feature of our moot court competition is that we don't reveal the identity of the colleges or the students, so they are given the unique code number, MP01, MP02. And now, their performances are arranged by drawing the lots. So first, I would like to tell about the preliminary round, which happened yesterday, which started from 9 a.m. in the college premises. Due to the more participants this year, we have organized 8 court halls. And in each court halls, 2 judges were there to assess the performance of the students. So total 16 judges who are the renowned advocates of High Court of Bombay bench at Aurangabad, they have assessed their performance. After that, out of 25 teams, this time 7 teams reached semi-final round. The rule is what? 6 final reached, but there was a tie between 2 teams. Again, yesterday only the semi-final round was conducted in 2 courtrooms. The senior counsels of again High Court of Bombay bench and Aurangabad, they assessed the performance of the participants, and at 7:30 we announced the result yesterday, and 3 teams qualified for final round. Today in the morning in this hall, the 3 teams have given their performances, and I am happy and thank the honorable judges who have given their consent and they have assessed the performance of the students. And now we are for the prize distribution functions. So to motivate the students, several awards are given to them. When the Jadhav sir is going to brief it, you will be able to know how the trophy is sponsored by our esteemed alumni. Runner-up prize is there, winner prize is there, individual prize like best memorial from final round, petitioner, respondent, all types of prizes are included, the awards and all. So whatever is happening, it is not only the coordinator or convener or co-convener is doing, it is a teamwork. So the preparation started last year in the month of September 2024, when the invitation of moot problem framing was sent to various law colleges. And after 1 month, it took 1 month time, we got the problem and the panel of judges, they gave the green signal, yes, this will be the 2 moot propositions. So for preliminary round, the problem was framed by Advocate Shahrukh Shah. And for the final round, the problem was set by Mr. Moot Pathan. So the problem was very interesting, and that can be a reason the students were attracted this time, and we have got so good response. Now, very soon, one of the faculty is going to announce the name of the prizes, and more importantly, again the unique feature of our college is what? Every participants are given participation certificate, along with every team is giving the participation memento, which you can keep as memory in your college. So that is also a unique feature, and I already told you that last year, September, we decided we were planning about these particular competitions. So it is a teamwork with the guidance of our respected principal sir, vice principal sir, IQAC coordinator madam, and definitely the implied and unconditional support of the members of the society, because their generosity, they have allotted a 3.5 lakh budget. But I was very nervous how to do such a celebration in grand way. So one of our alumni who is vice president and his brother, the name will already he has felicitated, Advocate Rajan Deshmukh sir and Advocate Avinash Deshmukh sir, they have contributed 1 lakh each. So we were able to do this program in a grand way. Now, faculty committees are formed, their tasks are allotted, non-teaching committees made, their tasks are allotted, and the backbone of the institution is our volunteers, student volunteers. So we are having our convener Aditi Ankush, co-convener Jay, and 36 volunteers together. They have worked very hard to make this program very successful. So I appreciate the leadership of our convener Aditi Ankush and Jay Gavre. And more importantly, every minute arrangement is made and suggestions always comes from our management and principal sir. So we have to select the trophies. It is also a very big task. So every year, Advocate Megha Deshmukh ma'am come with us and select the trophy. So this is the short brief. I thank the participants once again, and I conclude my speech. Thank you. I thank the organizers for giving me this wonderful opportunity. Thank you.
Thank you so much, ma'am. The true essence of any competition lies in the experiences of its participants. I now invite some of our distinguished participants to share their view. Firstly, I call upon Jayesh Thakre from MP15 for his feedback. Parth, be ready.
Good afternoon, everyone. Respected teachers, sirs, judges, and my all dear friends. It's my honor to give a vote of thanks. And actually, on the first day, the words of staff, I remember that you are now the part of the MP Law College as a family member, and it's our fortune that we became the part of MP Law College. Thank you, sir. Thank you, the every staff. And all the facilities were provided by college was very best, and all the committee team that managed the moot court competition has also supported very well, and thank you very much.
Now I call upon Parth Sharma from MP 17. Arpit Pandey, be ready.
A very good afternoon to the honorable judges, esteemed guests, respected teachers and organizers, and my fellow participants and students. I, Parth Sawan, am truly honored to stand before you. I would first of all like to begin by expressing my thankful gratitude to Manikchand Pahade Law College for hosting such a great competition. The hospitality, overall management, and attention to detail of the competition really impressed us all. Also, the volunteers were very cordial and helpful. But what is most important is that this competition was a great learning experience for us participants. The critiques and suggestions of the judges have helped us increase our legal knowledge and improve our advocacy skills. And a famous Chinese proverb reads that learning is a treasure that will follow its owners everywhere. And I am sure that the lessons which we have learned here will remain with us throughout our lifetime and will help us become better lawyers in the future. I once again thank you so much for giving me the opportunity to express my gratitude. Thank you.
Lastly, I call upon Arpit Pandey from MP12 for his feedback.
A very good afternoon to esteemed judges and all the participants and the management team of MP Law College. To emphasize on my team, this was our first external moot court competition, but to be very honest and to give a very genuine feedback, I have never seen such an amazing organizing committee member of this college. They were really helpful at each point of the competition. I remember when we qualified for finals, they even said to us that you don't need to go to outside for dinner, we'll parcel everything to your room, you can prepare for your finals. Moreover, lastly, I would like to emphasize on one point that last year I did my internship at the Honorable Supreme Court of India, where at that point of time, Honorable Justice C.T. Ravi Kumar was there at that point of time, and I had the privilege to witness his proceedings in his courtroom. Now, in front of a justice of Honorable Supreme Court, it feels really privileged to argue as a student to argue before a judge of Supreme Court. Thus, I thank all of the committee members of the MP Law College, and I hope that such a kind of wonderful event will be hosted every year, and we'll be participating more in future. Thank you so much, everyone.
Thank you to all the participants who shared their feedbacks. Leadership is about inspiring others towards a vision of excellence. It is now my privilege to invite Advocate Dr. Kalpalata Patil Bharaswadkar ma'am, President of Marathwada Legal and General Education Society, to deliver address to all of us.
A very good afternoon to one and all. Chief guest of today's function, Honorable Shri Justice C.T. Ravi Kumar, former Judge of Supreme Court of India, who was the judge of this competition and who kept the environment of today's moot court very lively and gave everyone feel of real court hall, and at the same time gave very useful, wonderful tips to the participants. Guest of honor, Honorable Shri Justice Kailash Chandiwal sir, former Judge of High Court of Bombay Bench at Aurangabad, who is pride of MP Law College, who is alumni of MP Law College. In spite of his busy schedule and in spite of his scheduled program, he gave us time and we are thankful to him. Principal Dr. C.M. Rao, Vice Principal, IKSC Coordinator of this event, Vice President and Secretary and other members of our society, invitees, participants and students. As I stand before you, I am feeling with a deep sense of nostalgia and pride. It takes me back 35 years when I was student of this very institution. This moot court competition was one of the most awaited and cherished event for me. Just I am sure that for many of you it must be most awaited event. And of course at that time it was state level competition. The excitement, the intellectual rigor and the competitive spirit that this platform fosters have always been integral part of shaping the budding legal minds. It is really a great pleasure to stand before you today as the president of this esteemed society that has nurtured legal minds for generations. Today marks a significant milestone in our journey because it's a silver jubilee of our national level moot court competition. This event is not just a testament to our commitment to legal education, but it is also a celebration of bright, aspiring advocates of tomorrow. Everybody will agree with me that moot court competitions definitely play an important role in shaping the careers of law students because this bridges the gap between the theoretical knowledge and practical knowledge. So sharpening advocacy skill, legal research, persuasive arguments. I am watching all the participants since yesterday, and it's really a pleasure to see young minds engaging in intellectual duels, arguing with precision, exhibiting legal acumen that promises a bright future for the legal profession. I extend my heartfelt congratulations to all the participants who took up the challenge and showcased remarkable talent and dedication. Competitions like these are not merely about winning, but also about learning, evolving, pushing one's boundaries. So for the winners, I will say, that your hard work, perseverance, and commitment have brought you to this well-deserved success. You stand here today as champions, not just of this competition, but of values of discipline, diligence, and determination. And for those who may not be able to secure any trophy today, of course, everybody will get the participation trophy. I would like to say that always remember that every argument presented, every counterpoint defended, and every case which you have studied has added a value to your journey. So, the true reward lies in the experience which you have gained, the lessons which you have learned. As future legal professionals, your path will be full of challenges, but the resilience which you built today will define your success for tomorrow. I take this opportunity to thank our esteemed panel of judges for the final round as well as for the preliminary and semi-final rounds, whose insights and expertise have enriched this competition. Your presence and guidance have provided the students with invaluable exposure to the realities of the legal world. I also extend my gratitude to our management members, particularly Senior Advocate Shri Rajendraji Deshmukh, Advocate Avinashji Deshmukh, for sponsoring the trophies and additionally for donation of rupees 2 lakhs specially for this Silver Jubilee competition. I congratulate Dr. C.M. Rao and his team, and particularly the volunteers who have worked tirelessly for making this event a grand success. As we are in the conclusion of this Silver Jubilee Moot Court competition, let us carry forward the spirit of excellence, ethical advocacy, and a commitment to justice. May this event continue to inspire young legal minds for years to come. Once again, congratulations to all. I wish you all success in your future endeavors. Thank you.
Thank you so much, ma'am, for all the guidance you have been providing to us. I now have the profound honor of inviting Honorable Shri Justice Sri T. Ravi Kumar sir, former Judge, Supreme Court of India, to share his invaluable insights. We are truly eager to hear from you, your lordships.
The princess of the function, Advocate Dr. Patil Baraswat, I don't know sorry for, and Brother Justice Kailash U. Chandiwal, Dr. C.M. Rao, Principal of Manikchand Pahade Law College, all other prominent on and off the podium, the participants, and all other students, and one and all who constitute my worthy audience. A very good afternoon. From 5th January 2009 to 5th January 2025, I was delivering justice as a judge. But today I know, if I am going to make a long speech, it will not be rendering justice. And I do not want to make the hungry angry. So I will try my level best to make it short. This moot court competition, I was thinking actually even while putting questions, I really put those questions to make the participant feel what is in store for them. If they are actually taking up this profession, they decided to wear the gowns. They must have the feel. But I can say one thing. If my college days, if this kind of a situation I was to face, I am sure that I could not have performed like this. Wonderful, wonderful. In an adjudicatory process, you know, there cannot be a win-win situation. That will happen only if mediation takes place. One is bound to be a loser. So, here also after the announcement of these results, we definitely will see happy faces, some dejected faces, but then this is the bitter and better experiences which you will have to face in your real life. In courts also, even the greatest of lawyers, they cannot claim that, yes, I won all my cases. No. It depends upon the merit of case. They must have performed well. So the question is, when somebody briefs you, somebody give a brief to you, the question is whether you conducted your case sincerely. It's all about that. You can only present the case very well. Leave it to the judges to decide it. So that you will have to understand from here itself. Sir was saying about sports. It will make you energetic, healthy, but then, as in this field also, it has another importance. Saying about sports, we will used to say about sportsman spirit. In this profession also, you must have had that. After arguing a case, of course, you will listen patiently what the judge say. Definitely, sometimes the verdict will be in your favor. Sometimes it will be against you. The sportsman spirit should be there. Accept the favorable and the other with smile. That should be the sportsman spirit which a lawyer has to show in court. Being a person who spent almost 4 decades on both sides as a lawyer and as a judge, I think, of course, as I undertook that, now I will not make a long speech, but still, I think that I should say something. Especially the subject of this Moot Court competition. I am sure that even for a lawyer, an experienced lawyer, this will be a very difficult one. In the context of this, I really wanted to say what our former Prime Minister, Pandit Jawaharlal Nehru, said in the Constitutional Assembly debates. While we want this constitution to be as solid as permanent a structure as we can make it, nevertheless, there is no permanence in the constitution. It is true, we call our constitution a living document. That is my assessment. Why? Because by amendment, by contribution from the court, it grows. It's a living document. And Pandit Jawaharlal Nehru said, there cannot be a permanence. That means there is scope for development. Amendments, of course, you must have heard so many in your school or college also. You must have studied about various amendments brought to the Constitution. So the power to amend it is there. Then the question is how to challenge it, whether it can be challenged. And if at all, on what grounds? What are the available grounds? That is why, to find it out whether you have made your homework, I put certain questions. I really expected something because in a case like this, part of your preparation, I do not know whether somebody had an occasion to go through one of the remarks made by one senior lawyer of the Supreme Court, Mr. Raju Ramachandran. He said that the basic structure doctrine is anti-democratic and counter-majoritarian in character, and that unelected judges have assumed vast political power not given to them by the Constitution. He said so. Don't think that I am saying anything about it in the context of this case. But at the same time, you must understand one more thing. If you are conducting a short survey of authorities on these litigations on judicial amendment, these constitutional amendments, between 1951 and 1973, you can understand one thing. As regards this, the constitutional amendments, two separate arguments for judicial review were accepted. Firstly, they are subject to judicial review under Article 13. I do not know whether anyone had gone through that, Article 13. You know where the law is defined, what is law. And then second, they are subject to basic structure review. And you know the basic structure, when we say about the basic structure, one cannot even say or think without making a reference to Kesavananda Bharati's case. That was, of course, related to land reforms. And being a person from where Kesavananda Bharati belonged, that is from Kerala, definitely I will have to say I am also from Kerala. Then, since this particular subject, I do not want to say much, because a person limited the office of a judge of Supreme Court, and this is gathering attention of the Supreme Court. And during my farewell speech, I said, I will not be saying anything or doing anything to shatter the confidence of the people in this system. So I am refraining myself from making any comment upon this subject. But at the same time, we know that on getting independence, on 15th August 1947, we are still continuing as a democratic country. If somebody puts a question, how it is possible? My belief, and I think that that is the belief of most of the people of this country, it is because of the independence of judiciary. One, and of course the second, the existence of an independent constitutional body called the Election Commission. This is assuming relevance in the context. So being persons who are now on the verge of going out from the college after graduating, the law students, you must bear in mind this thing, the independence of judiciary. Surely you may become lawyers and thereafter may move to the other side, that is, you may join the bench, but then understand that be a lawyer or a judge, you must bear in mind this independence of judiciary. You are there and you must be there to maintain it. It should be there. That is why our country is like this. Our country will continue to, I am sure, our country, great country, will continue to be a democratic country and will be an example for one and all in the world. So your duty is that after going out. And how you are going to perform all these things? As a lawyer or after graduating, it's not a simple one. There is only one mantra, hard work. If anyone scale heights in this profession, don't think that they have adopted some shortcuts. No. It can only be the hard work. That hard work is the one. And then sincerity. Be sincere to the court and above all to your client. That will take your success. And at the same time, always be a philomath. A philomath in the sense, a lover of learning. A student of law and a judge. Now we all in the legal fraternity, we have to be like that. Love of learning. Be a lover of learning. Every day, this learning process for the lawyers and for the judges. Don't think that the judges are there and they know everything. No, they are also learning every day. And I have had the opportunity to gain that and to learn that till the other day. Still, I am going. Unto my death, it should be like that because you are bound to be a law-abiding citizen. And therefore, if you do not know what is the development of law, what is the new law which is being enacted or which may enacted hereafter, so be a lover of learning, continue to learn, and then give proud to your own institution. Some of the participants, of course, whether students of this college, they are also participants. No. So all of you, make your institutions proud, your parents love this country proud. Thank you. I wish all success to all. And after announcement of our results, of course, there will be one winner. My congratulations to the winner. My commiseration to the loser. Thank you. Jai Hind.
Thank you, sir. All the students of Manikchand Pahade Law College and all the participating teams, we are truly, truly privileged to be in your presence, to witness the rounds which you assessed, and then to hear this enlightening guidance from you. Oblige your lordships. I now invite Mr. Abhay Zadav, Professor Abhay Zadav, sir, to declare the results, the moment we have been waiting for.
Honorable Chief Guest of today's function, Honorable Sri Justice C.T. Ravi Kumar, former Judge of Supreme Court of India, the Guest of Honor, Honorable Sri Justice Kailas Chandiwal, the President of this function and the President of our MLNG Society, Advocate Dr. Kalpalata Patil Bharaswadkar Madam, Principal, Vice Principal, IQAC Coordinator and Coordinator of this Moot Court competition, all the respected members of our MLNG Society and office bearers of this MLNG Society, all the participants and all our beloved students. Now the moment has come for which you have been waiting for. Your Lordship, at our institution we follow very unique practice. In order to encourage the student participants, we first start with the distribution of the memento, participation memento for each team. So hence now I would like to begin first with the distribution of the memento for your participation. This is an encouragement for all of you. So I request to come fast. I will call sequence wise. MP01 VM Salgaonkar College of Law, Mirmar, Goa. Please come fast. VM Salgaonkar College of Law, Mirmar, Goa. And I request Lordships to do the honor. MP2. No, sir. Please. This way that you have to stand. Next is MP2 SVKM Praveen Gandhi College of Law, Mumbai, Maharashtra. MP2. So those who are receiving the certificates requested to go by this side and come this way. Second, Praveen Gandhi College of Law, Mumbai. MP3, VVM's Govind Ramnath Karai College of Law, Goa. MP3, VVM's Govind Ramnath Karai College of Law, Goa. MP4, Savita School of Law, Chennai, Tamil Nadu. MP4, Savita School of Law, Chennai, Tamil Nadu. MP4. MP4, Savita School of Law, Chennai, Tamil Nadu. Next, MP5, RTMNUs, Dr. Babasaheb Ambedkar College of Law, Nagpur, Maharashtra. MP5. MP5, come first. Next, MP6, OP Jindal Global University, Sonipat, Haryana. MP6. MP6, OP Jindal Global University, Sonipat, Haryana. After this, MP7, National Law University and Judicial Academy, Assam. Guwahati, Assam. Naluja. National Law University and Judicial Academy, Guwahati, Assam, MP7. Next, after MP7, MP8, Yashwantrao Chavan Law College, Pune, Maharashtra. MP8 come first. MP8 is absent. Okay. MP9, KLE Law College, Bengaluru, Karnataka. MP9. MP9, KLE Law College, Bengaluru, Karnataka. After MP9, MP10, MMM Shankarrao Chavan Law College, Pune, Maharashtra. MP10, Shankarrao Chavan Law College, Pune, Maharashtra. Next, MP11, Shastra University School of Law, Trichy, Tanjore Road, Tamil Nadu. Shastra University School of Law, Trichy, Tamil Nadu. MP11. Next, MP12, Christ deemed to be University, Bengaluru, Karnataka. MP12. Christ deemed to be University, Bengaluru, Karnataka. Come, go first. Next, MP13, Christ deemed to be University, Pune, Lavasa Campus, Maharashtra. MP13. MP14, MVP Samaj Law College, Nashik, Maharashtra. MP14. MVP Samaj Law College, Nashik, Maharashtra. MP15, Akola Law College, Akola, Maharashtra. MP15. MP15 come first, Akola Law College, Akola, Maharashtra. Then MP16, ICFI Law School, Hyderabad, Andhra Pradesh. MP16, ICFI Law School, Hyderabad. Yeah. Next, MP17, ILS Law College, Pune, Maharashtra. MP17, ILS Law College, Pune, Maharashtra. Yes, come fast, please. MP17, ILS Law College, Pune, Maharashtra. Next, MP18, New Law College, Ahilyanagar, Maharashtra. MP18, New Law College, Ahilyanagar, Maharashtra. Come fast. After 18, MP19, Symbiosis Law School, Pune, Maharashtra. MP19. Symbiosis Law School, Pune, Maharashtra. MP19. Next, MP20, Kalinga Institution of Industrial Technology, deemed to be University, Odisha. MP20, Kalinga Institution of Industrial Technology, deemed to be University, Odisha. MP20. Next, MP21, University of Mumbai Law Academy, Mumbai, Maharashtra. MP21, University of Mumbai Law Academy, Mumbai, Maharashtra. MP 22, Manik Chand Pahade Law College, Chhatrapati Sambhajinagar, Maharashtra. MP 22. MP 22. Next, MP 23, Dr. Ambedkar College of Law, Chhatrapati Sambhajinagar, Maharashtra. MP 23. Dr. Ambedkar College of Law, Chhatrapati Sambhajinagar. MP 23. Next, MP 24, VN Patil Law College, Chhatrapati Sambhajinagar, Maharashtra. MP 24, VN Patil Law College, Chhatrapati Sambhajinagar, Maharashtra. MP 25, Symbiosis Law School, Hyderabad, Telangana. Symbiosis Law School, Hyderabad, Telangana. Thank you. Now the announcement of results. The very first, we would like to proceed with Best Memorial Prize for final round. This is from the MP Law College, consisting of a trophy, and this prize has been secured by MP 16P, Mr. Kunjal Bhatnagar, ICFI Law School, Hyderabad, Telangana. I request Lordship, Honorable Sri Justice C.T. Ravi Kumar sir, to do the honor. Best Memorial Prize for final round for securing highest marks in the memorial for final round, backed by MP 16P, Mr. Kunal Bhatnagar, ICFI Law School, Hyderabad. The next prize, Best Mooter from preliminary round, which is sponsored and known as Ghate Foundation Prize. This time, this trophy has been won jointly by two people, MP 12 respondent and MP 17 respondent. MP 12 respondent is Arpit Pandey, Christ deemed to be University, Bangalore, Karnataka, and MP 17 are Yash Deshmukh, ILS Law College, Pune, Maharashtra. There was a tie in a preliminary round. Both have jointly won this prize. That is Best Mooter from preliminary round, Ghate Foundation Prize. Thank you. Next is Best Respondent from final round, which consists of cash amount of ₹2,000 and a trophy in the memory of late Advocate A.B. Bajpai, which is sponsored by Dr. Sunita Bajpai, Madam, Principal of IBP Mahila College. Best Respondent from final round goes to MP 16 Respondent, Ms. Isha Narla Gauri, ICFI Law School, Hyderabad, Telangana. This consists of cash amount of ₹2,000 and a trophy sponsored by Dr. Sunita Bajpai, Madam, known as late Advocate A.B. Bajpai Trophy. 16 are Ms. Isha Narla Gauri, ICFI Law School, Hyderabad. Then next is Best Mooter from final round, cash amount of ₹2,000 and a trophy sponsored by Mr. Prashant Sirsamkar sir, Governing Council member of our Marathwada Legal and General Education Society, consists of ₹2,000 and a trophy in the memory of late Advocate Ellen Sirsamkar Prize. And this is secured by MP 16 petitioner, Mr. Kunjal Bhatnagar, from the same ICFI Law School, Hyderabad, Telangana. MP 16 P, Mr. Kunjal Bhatnagar, ICFI Law School, Hyderabad, Telangana. Okay. Ms. Kunjal. Ms. Kunjal. Now, very special prize, a person who secured Best Mooter in all the three rounds, preliminary, semi-final, and the final round. And this prize has been sponsored by Senior Advocate Rajendra Deshmukh sir, who is also Vice President of our MLNG Society, Advocate Avinash Deshmukh sir, Advocate Megha Deshmukh madam, and Mrs. Shruti Sanjay Godse, who has come all over from the Singapore over here to witness this special occasion. So this trophy has been sponsored in the name of late Advocate S.A. Deshmukh Trophy. And this is secured by, can you guess it? MP 12 respondent Arpit Pandey, Christ deemed to be University, Bangalore, Karnataka. So he has secured the highest individual marks in all 3 rounds. MP 12 respondent Arpit Pandey, Christ deemed to be University, Bangalore, Karnataka. Now the runner-up. This prize consists of cash amount of rupees 5,000 and a late Advocate S.A. Deshmukh Trophy sponsored by Senior Advocate Rajendra Deshmukh and family. Can you guess it? This goes to MP 12, Christ deemed to be University, Bangalore, Karnataka. MP 12, runner-up, prize goes to Christ deemed to be University, Bangalore, Karnataka, MP 12. And I request Lordships to do the honor. Congratulations. Now the last. I think now you can guess it. Team code. Before that, I would like to say the winner team prize, which consists of an amount of 7,000 rupees. And again, the trophy in the memory of late Advocate S.A. Deshmukh, sponsored by Senior Advocate Rajendra Deshmukh and family. Guess it? MP? Absolutely right. This is secured by MP 16, ICFI Law School, Hyderabad, Telangana. I request Lordships to do the honor, please. Winner team, MP 16, ICFI Law School, Hyderabad, Telangana. Cash amount of rupees 7,000 and a trophy in the memory of late Advocate S.A. Deshmukh. Have a huge round of applause, please. Convener. Thank you, Lordships. Your Lordship, now I would like to request, without whose this competition would not have been a success. These are our students of Moot Court Association. In a representative capacity, I request you to give the certificate to the convener and co-convener of this Moot Court Association, Ms. Aditi Ankush and Jay Gowde. I request Lordships to do the honor, please. Without Moot Court Association, this program would not have been successful. And this is an acknowledgement of the efforts of whole Moot Court Association and the volunteers. Thank you. And all the volunteers will be given certificate by arranging a special program. Thank you. With this, I stop. Thank you everyone for your.
Thank you, sir. A very, very big congratulations to all the winners and a very, very big appreciation to all the participating teams. Gratitude is a fairest blossom that springs from the soul. As we come to the conclusion of this prestigious Silver Jubilee Moot Court competition, it is my honor and privilege to extend a heartfelt vote of thanks to all those who have contributed to making this event a resounding success. First and foremost, our deepest gratitude to Honorable Shri Justice C.T. Ravikumar sir, former Judge Supreme Court of India, who graced this occasion as our chief guest and also judged the final round of the competition. Sir, your presence has not only elevated the stature of this event, but also provided invaluable insights and inspiration to all of us present here. A special note of appreciation to Honorable Sri Justice Kailash Chandiwal sir, former Judge, High Court of Judicature at Bombay, bench at Aurangabad, our guest of honor who also judged the final round of the competition. Sir, we are deeply grateful for your time and esteemed presence among us. Our heartfelt thanks to Advocate Dr. Kalpalata Patil Bharaswadkar ma'am, President of Marathwada Legal and General Education Society. Ma'am, your leadership and vision has been instrumental in shaping legal education at our institution. Our heartfelt thanks to Mrs. Saira Ravikumar ma'am for her esteemed presence with all of us. We are truly grateful, ma'am. We also extend our gratitude to office bearers of Marathwada Legal and General Education Society, Advocate Rajendra Deshmukh sir, Vice President of MLNG Society, Advocate D.S. Kulkarni sir, Secretary of MLNG Society, Advocate Narendra Deshpande sir, Joint Secretary of MLNG Society, and all the respected members of Governing Council and Society of Marathwada Legal and General Education Society, whose continued dedication and leadership enable us to organize events of such an excellence. A special note of appreciation to all our generous sponsors whose contributions have added immense value to this competition by recognizing and rewarding excellence in advocacy. First and foremost, Advocate Rajendra Deshmukh sir, Advocate Avinash Deshmukh sir, Megha Deshmukh ma'am, and Shruti Godse ma'am for sponsoring the trophy of winner team, the trophy of runner-up team, and trophy of best mooter in all round. In the memory of late Advocate Shri Sudhakar Rao Deshmukh sir. Deshmukh family has truly been backbone of this competition. Also, I present my thanks to Advocate Prashant Sirksamkar sir for sponsoring the trophy of best petitioner from final round. In the memory of late Advocate L.N. Sirsamkar sir. I also present my thanks to Dr. Sunita Bajpai ma'am, Principal of IBP Mahila College, for sponsoring the best respondent from final round trophy in memory of late Advocate A.B. Bajpai sir. I also extend my gratitude to Ghate Foundation Aurangabad for sponsoring the best mooter trophy from the preliminary round. Your generous contributions have not only encouraged our participants, but have also played a crucial role in fostering excellence in legal advocacy. We extend our deepest gratitude to each one of you for your invaluable support. This competition would not have been possible without the dedication and expertise of our esteemed judges. Our deepest gratitude to judges of semi-final round, which was held yesterday. First and foremost, Senior Counsel Advocate V.D. Sapka sir, Senior Counsel Advocate P.R. Kathneshwarkar sir, Advocate Anjali Dubey ma'am, and special mention to Advocate Mahesh Bharaswadkar sir for giving his time despite such a short notice. Your experience and insights have truly challenged and inspired our participants. Our sincere thanks to judges of the preliminary rounds, whose expertise ensured a fair and rigorous competition. We extend our appreciation and gratitude towards Advocate Rajendra Godbole sir, Advocate Girish Vani sir, Advocate Milind Patil Bidkar sir, Advocate Ajit Kadethankar sir, Advocate Sandeep Mahajan sir, Advocate Sharad Natu sir, Advocate Nilesh Ghanekar sir, Advocate Amit Yadkikar sir, Advocate Devdatta Palodkar sir, Advocate Mukul Kulkarni sir, Advocate Parag Balde sir, Advocate Chaitanya Dharurkar sir, Advocate Shailendra Gangakhedkar sir, Advocate Rahul Joshi sir, Advocate Atul Kale sir, and Advocate S.V. Salunkhe sir. Your dedication and impartial judgment have played a pivotal role in maintaining the high standards of this competition. A special note of gratitude to our respected and beloved principal, Dr. C.M. Rao sir, for his unwavering support and mentorship to all of us. Our sincere thanks to Professor Shri Krishnan More sir, Vice Principal, and Dr. Aparna Kotapalle ma'am, IQAC Coordinator, for their guidance and motivation to all of us. A heartfelt thanks to Dr. Anju Singh ma'am, Faculty Coordinator of Moot Court Association. Your relentless dedication has been truly inspiration for this competition. We also extend our gratitude to Professor Abhay Zadav sir for announcement of prizes and all the support. All esteemed faculty members of Manikchand Pahade Law College for their encouragement and invaluable contributions. We are all grateful to all of them. A special mention to non-teaching staff whose tireless efforts behind the scene ensured the seamless execution of this event. A special mention to Mr. Venkatesh Gaikwad and Ms. Omisha Priya for introducing the judges. Also, a very great thanks to Venkatesh for making a beautiful brochure of the competition. A sincere thank you to press and media representative and also our very beloved photography team for their coverage and support, ensuring that the spirit of this competition reaches a wider audience. To all the teams that participated in this prestigious competition, we extend our deepest appreciation to each one of you. Your dedication, enthusiasm, and remarkable performance have truly enriched this event. We hope this experience has been as rewarding for you as it has been for all of us. Last but certainly not the least, a very special and heartfelt thank you to all the volunteers, the true pillars of this competition. We have had the privilege of working with a team of dedicated, hardworking, and passionate individuals who have put their endless hours to ensure that this event is executed flawlessly, and we deeply value and sincerely appreciate all your work. Lastly, to every single person who contributed in any way, whether big or small, to making this event a success, we express our heartfelt thanks. Your support, encouragement, and dedication have made this Silver Jubilee Moot Court competition organized by Marathwada Legal and General Education Societies, Manikchand Pahade Law College, a truly memorable and remarkable event. With this, we formally conclude today's proceedings. Now, with the permission of the guest, I request everyone to please raise for national anthem. एक साथ सावधान, एक साथ राष्ट्रगीत शुरू करेंगे, शुरू कर। जन गण मन अधिनायक जय हे भारत भाग्य विधाता, पंजाब सिंध गुजरात मराठा द्राविड़ उत्कल बंग, विंध्य हिमाचल यमुना गंगा उच्छल जलधि तरंग, तव शुभ नामे जागे, तव शुभ आशीष मागे, गाहे तव जय गाथा। जन गण मंगल दायक जय हे भारत भाग्य विधाता, जय हे जय हे जय हे जय 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 हे जय। Thank you, dignitaries. Thank you, participants. I request all the winners, participants, and volunteers to stay back for the group photographs. Thus, we conclude the Silver Jubilee Moot Court Competition 2025.